logistic issues because of both the House and Senate committees on judiciary going this afternoon. So we got members of both committees going back and forth. We've got a number of bills that we're going to be hearing. I know one of the bills, which many of you hear of interest, is Senate Bill 292. You recall we did have a hearing on the House bill of the similar type issue, which was, what was the number? I forgot.
292 and
831? 861. If you will bear with us, a number of you have signed up to speak. We're going to have to limit the amount of speaking on the bill. I would probably, if I'm not here at the time, if Mr. Jacobs is here serving as the chair of it, I've talked to him about it. What we're going to do is ask you to stand to be recognized as to who you represent, and if you're opposed to the bill, so state, and we'll handle it that way as opposed to requiring or asking you rather to come up and speak to the committee as a whole as a witness. We've got several things. I know that Mr. Bruce, you wanted to be recognized before we start the meeting.
Yes, sir, and thank you, Mr. Chairman. I was trying to allow one of the constituents, Ms. Green, who was here yesterday, to speak on the Bill 292. She has come back today, and unfortunately she has a commitment where she has to be away for a court case that involves a family member. So if you would allow her to speak.
Why don't you ask her to come forward, and we'll be glad to have her speak to us. And we have a chair that you can pull out and be comfortable. If you would give us your name. And
Zulima Green, and I am a constituent, and I just had a couple questions regarding this bill. The main thing is, I see that the purpose is to try to make sure that TANF funds aren't used for illicit drug use, but my concern is there any evidence to suggest that there are funds being used for illicit drug use? I guess it just seems like there are enough regulations on the books as it is in order to enact additional legislation to target something that there's no evidence to suggest is a problem. The other thing is, my concern is the constitutional issues with warrantless search and seizure of these individuals, and whether or not the legislators are prepared to protect the rights of the poor constituents who essentially this bill is targeting. So those really were the two main points that I wanted to make sure that you guys undertook prior to adopting such legislation. And
we appreciate that. Those are issues that we have been addressing as we've had individuals such as yourself address the committee, and we will continue doing so before we take action.
Okay.
We're grateful for you being here today.
Thank you.
And thank you for coming, appearing before us. Is Senator Hamrick? Yes, ma'am. Yeah. Oh, not necessarily. No, I can take care of that.
Okay.
I can take care of that. I want to say part of the logistics will be to get Senator Hamrick up first so he can get out to his committee if he's arrived. I don't know if he's here yet. Okay. What is his bill number?
136.
136, yeah. Welcome, Senator. We were awaiting you to be the number one bill and number one in our hearts.
Thank you. Thank you very much.
That's right.
Mr. Chairman.
And your bill number again is 136. I passed it up somehow. Here we go. Thank you. We'll hear about 136, Senate Bill 136, presented by Senator Hamrick.
This legislation deals with situations where there is a condominium development and the developer basically doesn't follow the requirements that a board be set up and that there be a budget and there be assessments and that it run kind of like a business. And I've heard lots of specific problems in this area, and actually experienced it myself, where the developer basically just doesn't set up the board, so there's no reserves set aside for roof repairs and all those things that you're supposed to do. And in our case, what we did was basically set up the board ourselves, but we did it with the consent of the developer, and we realized through all that process that it'd probably be good if we had in law that if the developer does not set the board up, the owners of the units can set the board up and have a budget and start collecting the assessments and the reserves. And that's what this legislation is intended to do, is just short of having to go to court and file all the civil lawsuits and stuff to get it to happen, just have a mechanism for it happening that involves the people who actually will benefit from that, and that's the property owners.
Thank you. Questions of the presenter? Let me, if I might ask, since the triggering mechanism and process you would go through is they would have what period of time to do the requirement of setting up their boards? And I guess we're saying following whatever the declarations they have put with the property. If they didn't do it by, what I'm guessing is sometimes they have them set up where, let me back up. They're set up initially as the time of the property is developed. And so now you have units sold. They do nothing as far as starting the board. And then you go through what, a notice process?
Yes. When the declaration is filed, it obviously has all the statutory requirements in it if it's done properly, and those requirements are that a board be set up and functioning. The declarant still controls the board basically, and actually can set up his own board, or his or her own board. A lot of times they just don't do that, and so there's no governing body to establish a budget. They won't have a budget. They won't have annual meetings.
Gotcha.
You know, it just won't function.
So both of them require, once there's a certain number of percentage units sold or whatever, they will then turn it over to the homeowners for control. But up at that point, they're the ones who maintain the control of the board, and even in those circumstances, they're not doing it.
Right.
Okay.
This would just if the
save them
developer
money
doesn't
as well
have his own board, then the owners can set the board up.
Okay. Anything further by members of the committee of Senator Hamrick? If not, we appreciate your bringing this to our attention. And I know you've got a committee meeting. This is the only bill you've got on our agenda, I believe, today. You've got a committee. Anyone else wish to speak on Senate Bill 136? If there's no one else, we will close off further public comments. The bill is now in the breast of the committee. Is there any discussion among the committee regarding Senate Bill 136? If not, the chair will entertain a motion.
Do pass, Mr. Chairman.
Everybody's anxious to move do pass.
I don't even have a bill in Senate, Judy, this year.
And seconded. So I think it's been unanimously moved and seconded.
Thank you, Mr.
Chair will
Chairman.
call for the question. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you.
Thank you.
I believe Senator Carter, was he here? I think he's on your committee too. There you are, Senator Carter. I'm going to call you up next, because I know you got to get back over there also, do you not?
Yes, Mr.
You're
Chairman.
here on an evidence bill. This is Senator Carter's bill, Senate Bill 31, evidence.
And it is an evidence bill, Mr. Chairman, and I appreciate it. And as I said, as eager as we were to move Senator Hamrick's bill, the Judiciary Committee is holding up Johnny Meadows in the other house, and they're ready to move that bill out too. I'm sure they need a quorum. So
All right.
but we very much appreciate you hearing this and appreciate the suggestions that have been made for the bill. It is an evidence bill that passed both Representative Jacobs' subcommittee unanimously last year and this committee unanimously last year. It does need to be the substitute that you have in front of you, I believe, is LC 400190S.
That's correct.
And it will, given the passage of the evidence code last year,
Wasn't that great?
it was a wonderful, wonderful benefit both to the business and lawyers in this state and to the administration of justice, and it was it was honor for me to get to vote for it in the Senate. And having done that, this bill was, at the time it was drafted, it was a hopeful bill that anticipated the passage of that. But now that it has passed, the entirety of Part 1 is unnecessary, essentially. So if it's because we already have a substitute, at least in the Senate, the way we would do it is have a new one. That I would suggest we delete Part 1 in its entirety,
All right.
so that
This is dealing with the privileged communication.
yeah, and then this Part 2 deals with the privileged communication still. And it is the same subject matter that passed this committee unanimous, as I mentioned last year. But rather than amend the old law, we will just amend the new law established under the evidence code. So Part 2 is the meat of the bill that was passed through this committee last year, and what it does is it expands the privilege circle only with respect to attorney-client communications, and only in determining whether or not those communications are privileged. It includes the parent in that privilege circle if the child has been accused of a crime. What that means is that if a child has been accused of a crime and the parent wants to be a part of their attorney-client communications, the parent can do, and the attorney and the child want the parent to be a part of the communication, the parent is brought within that circle without waiving the privilege. Currently, the parent has to be excluded unless the attorney and the child want to waive or break that privilege. So it allows parental involvement, and that the parent is defined. Section or Part 3 of the bill, and again that's the provision that passed last year, and again it just encourages and allows parental involvement without breaking the attorney-client privilege, where you have a 9-year-old accused of a crime or a delinquent act, or a 13-year-old accused of a crime or delinquent act. Part 3 of this substitute is the result of it also clarifies a portion of our evidence procedures in court and with respect to determining present value of medical expenses and living expenses and other issues. Right now, the law is somewhat unclear about how you make a determination as to a reduction or determining present value of future expenses by expert testimony or the 5% discount rate. This merely clarifies that you can use either expert testimony or the 5% discount rate.
This is known as the Andy Owen Bill Clark legislation.
And if those two people agree on something, Mr. Chairman, as you know, it must be good bill. The last change to the substitute that you're looking at that I would recommend is, because as I mentioned we did pass the evidence code, we would suggest that it would be Section 3 of the bill, or Part 3 of the bill, makes the entire effective date just be January 1st, 2013, which is the effective date of the evidence code, and therefore all of these would just go into effect at that time.
Well, let me look at that for a second.
And I have a marked up copy from
Section
Travis.
4,
Yes.
1 has 3 dates,
Correct.
and we talk about this act shall become effective July 1, 2012, except otherwise provided by Section B, and you're doing Section B as to Part 2, and then we have Part 1 of the act shall stand repealed. We don't need to even do that, do we?
Correct.
Okay. All right, so
So it would be it would just read, this act shall become effective on January 1, 2013.
strike out B in its entirety and change the date of A to 2013.
January 1, 2013.
All right.
And then it's strike except as otherwise provided, etc.
Thank you. Questions of the presenter by members of the committee? No one has a question. Let me go back to our provisions on the Section 2.
Yep.
Part 2. The parent becoming a part of the privileged communication, how is that to be addressed to the court, if need be?
Well, when there is a communication that involves, I mean, generally, the same way that any other attorney-client issue would arise with the court, if I understand the question. So they would come and say this communication is attorney-client privilege, and the proof for that is the people who were involved in the communication were the attorney, the child, and the child's parent. And that would identify that as within the type of communications that are excluded on the grounds of public policy.
So any communication itself would rise to that level, and not a, trying to think how I want to phrase this, not anything that is only related to criminal conduct or delinquency acts.
Yeah, it does. The only thing that it changes, the general law of attorney-client privilege would apply. It has to be for the purpose, for example, of obtaining legal advice, or communications relating to that legal advice. And the only time that it includes the minor's parent is if that minor is accused of a crime and is seeking, or is seeking counsel in such a matter. So it's limited. For example, if it was Justin Bieber and he was negotiating a contract with his attorney, his parent would still break that privilege.
Right. Okay. Further questions of the members of the committee? If not, we will also ask if anyone in the audience wish to address this bill, and we do have people. Senate Bill 31. We have some signed up. You're right. I think we first have Ms. Sandra Michaels. Sandy?
Thank you, Mr. Chairman.
Let you come up here. Get one of the mics, please, if you would.
Yes, sir. And I have worked with Senator Carter on this, and I had proposed some language I think that is printed out, and I do want Senator Carter to stay here. The public defenders, public juvenile defenders, and others that represent juveniles were extremely concerned that this section labeling the parent a client creates all sorts of practical problems, because oftentimes the parent wants to tell the child how they should handle their legal work or try to step in. And I had proposed some language that I've shown Senator Carter that I and the juvenile public defenders felt made it very clear that it's for purposes of communication only. And I would defer to someone else if there's a better language that makes it clear that the term client, defining the parent as a client, only applies to a communication situation. Otherwise, you could read in paragraph 1 in lines 111 through 116 that the parent would be a client on equal footing with the juvenile accused of a crime, and I think that creates a problem in handling them. I'm sitting here trying to think of language, and I've got folks, I'm looking at my BlackBerry only because folks are trying to help me.
You don't have language ready for
I do.
this?
It's
No,
printed out,
no.
and
I'm asking. Let me finish my question, please,
oh, I'm sorry,
ma'am.
sir.
What I'm reading is part of what he has suggested be stricken entirely, which is all of section part 1, I should say. What you're wanting to address is under part 2.
Yes, sir. I didn't understand.
So
yes,
this
sir.
language would not be applicable to what you're talking about.
Yes, sir. It would be.
It would be.
It would be. And on page 4, it would at line 112. You would delete such terms shall include a minor's parent if the minor is accused of a crime or delinquent act or seeking counsel in such matter, through all the way, provided, however, that when the person is a minor accused of a crime or delinquent act, comma, only, and then delete all that and substitute the language that's printed out before you. And then we've been requested to keep the minor has the right to waive the attorney-client privilege.
May I try to read what you're talking about?
Yes, sir.
So you would say with the striking begins such, you would insert, when the client is a minor, comma, communications between a parent, comma, the child and the attorney are subject to the attorney-client privilege, period, and then only the minor has a right to waive the attorney-client privilege. Is that your proposed wording?
Yes, yes.
Am I correct?
When the client is a minor, comma, communications between a parent, the child, and the attorney are subject to the attorney-client privilege, period. Only the minor has the right to waive the attorney-client privilege, period.
Any questions of the witness? You have Mr. Hatfield.
Thank you, Mr. Chairman. Ms. Michaels, just to clarify the intent on this, and I think that it's good, but if we were not to adopt that amendment and leave it as is, basically you may have problems for the lawyer in who the duty of loyalty flows to in terms of the child or parents. Is that right?
Yes, that was our concern, and I understand completely what Senator Carter's doing, and I think my proposed language preserves what Senator Carter wants to do, but makes it clear that it's not, the client is not the parent.
Right. And just one suggestion I was going to have on that, on the proposed amendment, where you have the communications between a parent, I would add a parent or parents, comma, the child and the attorney.
We got definition, I think, on paragraph 2 of parent. It's defined.
Yes, but I'm just saying, making clear that if it's a communication involving both parents, the child and the attorney, that both parents are covered.
All right.
In a joint situation.
I did struggle with making it plural, not. I wasn't sure which would be more appropriate based on subsection 2 definitions.
All right, let me see. We have some more questions, Ms. Michaels. We have Mr. McKillop.
Thank you, Mr. Chairman. I have alternate language, and I'll maybe suggest this as a friendly. As opposed to your language, what about if you added at line 112 before the word such, the phrase, only for purposes of invocation of the attorney-client privilege, comma, such terms shall include. That limits the applicability of the exception to only the circumstance when the privilege is sought to be invoked.
It sounds good to me, but it's language isn't my strong point.
We'll take that when we get to the point for considering the bill. Mr. Jacobs?
Well, I'll yield for the time being. I mean, it appears with what we're doing with Ms. Michaels' proposed amendment is placing operative language into a definition, and I'd be very uncomfortable with that approach. So, I mean, I do think we need to be careful how we solve this problem so as not to create additional problems by putting, language in a definition that is, operative language, which is not where people would be going to look for operative language. Does that make sense? You don't look in definitions for, I mean, you look in definitions for the scope of the law, but you don't necessarily look in definitions for the law itself.
I understand. Yes, I understand what you're saying.
Well, that was some wisdom there.
Okay. Is that Ms. Dobbs? No, Ms. Stevenson, excuse me.
Mr. Chair, that was me, but I'm going to waive until we get to the wording on the amendments.
All right. I'm about ready to table while we go back and redo this, because I don't want to have it become even after passage, something we may have incorrectly handled.
May I be excused, Mr. Chair?
Pardon me?
Would you like me to step away?
No one else has questions of Ms. Michaels? You can be excused.
Thank you.
One last thing first. We have another individual, Andy Mayo. Have a seat, Mr. Mayo.
Thank you.
Introduce yourself to us, please.
Good afternoon. My name is Andy Mayo. I'm a student at Emory University with the Barton Child Center. We are grateful to Senator Carter for bringing this bill. It grew out of his support for the Child Protection and Public Safety Act, House Bill 641, which was approved by this committee and passed the House in February. Specifically, this bill supports parents' involvement with their children when their children are in trouble. And parent involvement often leads to better outcomes for children. And so we reviewed the language that Senator Carter and then also the language that Ms. Michaels proposed, and we would support that amendment as well.
Thank you. Thank you. Any questions of Mr. Mayo? I see none. Thank you for being with us today. Was there anyone else who wanted to speak on the bill? I'm going to have to ask Ms. Travis, if you will, please. Are you coming around to join us? Or? No, I'm coming to get a book over here. Title 24, is it going to have the new provision in it, though? Mm-hmm. It does? Mm-hmm. How about that? Well, thank you. Word. Yes, sir. I'm going to ask Ms. Travis when she has a chance to look at it if she is feeling, as I may somewhat myself feel, a little need to get this thing clarified, because they look at the whole code section and see what we have there as to the provisions about the thing I had a little problem with language-wise is talking about their being with the child, the parent rather, being with the parent becoming a part of what is the attorney-client privilege, even under the language that Ms. Michaels has. So we got to try and deal with that. Now, what were you going to? Would you like to say something?
Thank you, Mr. Chairman. And we had a discussion very similar to this last year. I believe Representative Hatfield raised it. As I understand what this definition does, as Representative Jacobs pointed out, it's only for use in this code section. And the code section is only about communications and whether they are excluded on the grounds of public policy. So it does not change any aspect of the attorney-client relationship. It only changes which communications are excluded. That said, I think that if we wanted to be doubly sure, then Senator McKillop, or excuse me, Representative McKillop may have come up with a way to do that.
Here's what we're facing, and I guess we'll give Ms. Travis a minute. We don't want to have the parent become a part of the relationship as a client.
Correct.
If I read this, it does. I think what we'll say is that the parent cannot be compelled to testify to matters that were obtained in the discussions between the child and the parent when there's a client relationship. You follow me?
And it also...
what you got is a limiting, you cannot... the limiting of the court's ability to compel testimony.
But you also don't want them to be somebody that breaks the privilege, whether so that in other words, a communication between the child and the attorney still must remain privileged if they are a part of it.
It cannot be waived. Yeah. Okay.
Yeah.
Mr. Hatfield.
Well, Mr. Chairman, that was just the point I was going to make too. That if you have a third party that's involved in an attorney-client communication, that would waive the privilege.
Mm-hmm. Mm-hmm. Ms. Travis, I want your thoughts.
Well, 24-5-501 says there are certain admissions and communications excluded from evidence on grounds of public policy, including but not limited to the following. One of them is in a communication between an attorney and a client. And the effort here was just to expand the word client to include the parent only in these limited circumstances where the child is accused of a crime or delinquent act and is seeking counsel.
I don't know who knows.
And I worked on this for a long time last year. I feel like
Who worked on it last year?
Senator Carter.
You and Senator Carter, okay.
If you just read it on this piece of paper, it's a little difficult to follow, but when you look at it in the context of the code, as I understand it, we're accomplishing the goal.
All right, with the language as it is.
Yes, sir.
Okay.
And I agree with Representative Jacobs that if you want to manage more operative words, the place is not the correct in the definition.
Mm-hmm. Very good. So what I'm hearing from Ms. Travis is she is comfortable with what we have as current language under Part 2-1. Right?
Yes, sir.
Okay. Mr. Jacobs?
I actually am as well, and I remember this issue now from some committee last year. I mean, the key here, and I think this alleviates Ms. Michaels' concerns, is that the lead-in for subsection B, there is, as used in this code section, the term. And then it goes into the, the terms that are used in this code section. I mean, the code section itself deals only with privileges. So I think it is on its face limited to privileges and really can't be used outside that context. So I don't think it's necessary to amend the bill at all. And now that now that I've listened to enough of this discussion, I remember the issue coming up specifically in subcommittee last year.
Very good. Is there anyone else who would like to address the committee on Senator Carter's Bill 31? If not, we will close all further public input, and the bill is now in the breast of the committee. Is there any discussion on the bill? First of all, there being no discussion, the chair will entertain motions.
Do pass, Mr. Chairman.
We have a motion to pass. It has been seconded. Any discussions on the motion? We have any amendments?
I have two amendments, Mr. Chairman. The first amendment is to delete Part 1 of the bill in its entirety and renumber the remaining parts accordingly.
So down through 104, we're striking, except we really begin with the lines 15. Begin with line 15 through 104.
Correct.
All right. Is there a second to that motion? It's been seconded. Any discussion on the motion? If not, we will call for that motion, which is the Jacobs amended motion number 1. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any other motions?
Second amendment, Mr. Chairman.
State your amendment.
That is on line 145, delete the subsection A designation, then leave this act shall become effective on, and then strike everything else in that section and replace it with January 1st, 2013, period.
All right, so what's your section 4 and part 4, section 4.1 will read after your amendment, if it's passed, will be this act shall become effective July 1, 2013.
It shall become effective on January 1st, 2013.
I'm sorry, January 1st, which is when the code becomes effective, I believe, isn't it? All right. That amendment understood. Is there a second to it? Second. We have a second. Any discussion on the Jacobs Amendment 2? Not. We'll call the question. All in favor of the amendment signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any further amendments? Not, the chair will call the main question, which is a do pass Senate Bill 31 as amended by, what's that?
Did you all adopt that part?
It's already in there. It's in there. It's in the bill. It's in the bill. Then we're doing Senate Bill LC 40-0190, which is Senate Bill 31, which already has the language. She was raising a question about Part 3. It's already there, but it's now known as Part 2. Back to the main question, which is do pass Senate Bill 31 as amended. Committee substitute. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. At this point in time, let me mention to Senator Rogers, I am going to be going over to the Senate rules to get my bills heard first. We're going to hold up on Senate Bill 234, with your permission, till I come back, which, if you need some time, maybe about another 20 minutes. I'm not rules, I'm sorry, Senate Judiciary. Beg your pardon. I made a mistake.
Yeah.
Thank you for catching that.
Yeah, he panicked me. I was leaving too.
Is that all right? Okay. We've got several amendments, and I think you are you aware of them all? I'm not aware of any. Come and get these amendments for him, Ms. Lottie, and I will, hand them over there. That's the bill with the amendments. I will at this point turn over the further chairing of the committee. Thank you to Representative Jacobs.
anyone come? Well. All right. Next up, we have Senate Bill 312. Senator Ligon, I understand you need to join your colleagues over in Senate Judiciary, correct? All right.
Proceed if you're ready.
We're ready.
Okay. All right. This bill requires that, well, it creates a pilot program in 5 counties in the state, and it would require within those counties that those who are eligible for food stamps to attend professional development activities as approved by the department, including working towards your GED, attending self-development classes, or enrolling in adult literacy classes. And the purpose is to provide those who are on food stamps to receive some training to help them become self-sufficient. And if you look at the numbers, those on food stamps in Georgia, it's a pretty staggering number. We have 1.9 million people on food stamps. Of those, 870,000 are minors. There are just over a million adults on food stamps. Those between the ages of 18 and 59 number approximately $565,000. Dollars, I mean people. And so there are obviously a significant number. But of that number, almost 2/3 don't even have a high school education, or don't have it's the equivalent. So obviously we want to begin moving them towards some training to help them become self-sufficient. Now the federal food stamp program known as SNAP has a component. It requires you, if you're receiving food stamps, to work, or the state can have a work training program as a part of that to move people towards self-sufficiency. And the federal government will also provide funding to help administer that program. It'll provide 100% of the administration cost, and then 50% of the incidental costs, such as transportation and child care for those that are receiving the benefits. Now there are certain exemptions in federal law which are included in this bill, so that there are obviously some people that can't do that because they may be mentally or physically handicapped. They may be under the age of 16, over the age of 59. If they're a student, you have to be at least enrolled part-time. If you're employed and working 30 hours a week, if you're participating in a drug and alcohol treatment and rehabilitation program, if you're receiving unemployment insurance, if you're a caretaker of a dependent child under the age of 6 or an incapacitated adult, then you would be exempt under federal law, and obviously you would be exempt under this as well. Before the recession, the state had been moving towards this, looking at this, trying to implement this. We do have one county that has a program like this right now, and that is in Paulding County, but that's strictly on a voluntary basis. People just have to volunteer to go, and there's not much participation in it. Within the federal guidelines, there's some leeway to allow the states to work with nonprofits, technical schools, other educational providers to try to have some flexibility to structure something that might work best with the states. Other states are moving along with this, and they're seeing some success. This bill would only take effect upon funding of the program.
There is a cost for the pilot program. It's about $11.5 million according to the fiscal note. But one of the things that we would want to look at doing is seeing how you can administer this in the most cost-effective way, so that we would receive some benefit, and again, move those who are on the food stamp program, begin moving them and preparing them to become self-sufficient. So.
Questions for Senator Ligon. Representative Bruce.
Senator, do you know any college graduates that are unemployed?
Oh yes, sir. There are plenty of people that are unemployed right now, but again, this is not this. There's an exemption for.
Okay, but you know people that are unemployed that are very well educated. Is the point that I'm trying to make.
Right.
And as such, we have situations where people who just happen to be on food stamps are now being forced to do something on the presumption that it's going to get them employed. That they get a GED, so now they're going to get employed. I mean, that's what I think I heard you say a minute ago.
Well, as a general rule, if someone has a high school diploma, then their chances of getting a job or a better paying job is better than someone that doesn't. And someone that has technical training has a better chance of getting a higher paying job than someone that doesn't.
Although we have a large group of our population that have college degrees, advanced degrees, and other kinds of degrees that are unemployed because the economy is such that it just doesn't have the jobs to put all these people in place. I guess what I'm getting at is it not a better, is there another way to create more jobs so that people can go to work with whatever skills that they have, and those that want to improve themselves, by going and getting a further education, they could do that. But to force people to choose to take the time to do what you're suggesting versus spending that time going out trying to find something where they could actually eat. I guess, this is just another program that you're talking about targeting a group of people who are already having a tough time trying to survive. And now you want to give them another hurdle to overcome.
Well, actually, I don't see it as a hurdle, and I see that asking someone to prepare themselves to become self-sufficient, I think there's a lot of dignity in that, and I don't think there's anything wrong with that. If in fact
that was going to happen, if there was a direct correlation between getting, this GED and finding employment, I would agree with you. But when you have people who are unemployed with with degrees, I know a couple of lawyers that are unemployed right now. I'm just saying, there's no direct correlation that says if I go and I spend the time doing this, that I will therefore get a job.
Well, we do know that recessions and times of prosperity come in cycles, and we certainly have been in a recession for some time, and we have been seeing some slight improvement of growth in the state. We're seeing some improvement in the revenues that are collecting. And so, with the hope that things will be getting better, the question that we have to ask ourselves is, why should we not begin to give those who may not have the tools to have a better paying job and to have a better life? Why not say, listen, we're giving this benefit. We're presenting you with this opportunity to improve yourself and to improve your lot, to have some more training. And this is not something that is just something that's spur of the moment. This is a stated policy within federal law that's been in place for some time. It's just that we're not fully utilizing that as a tool to try to prepare and train the citizens of the state of Georgia who may not have a high school diploma, who are on receiving food stamps. So,
Representative Evans.
Thank you, Mr. Chairman. Just a couple of questions. I know you said that it's not your intention for this act to go into effect unless we have money to pay for it. So does your bill, would it call for the state to pay for these GED classes or other self-improvement activities that these folks might engage in? Or is it your intention that they would pay for them themselves?
Well, no, those would be provided for them. You can't require a recipient of food stamp to pay that cost for you. That's why under the federal law there's coverage of 100% of the administrative cost and 50% of the other costs, such as transportation to and from the class and other incidentals. So.
Okay, thank you. And then just a couple more. Is on line 44 where you refer to some of the folks that are exempt from this, including primary caregiver of a dependent child under 12 years of age, is that language from the federal code, or if it's not, what is the magic of 12?
That 12, the 6 years of age is under the federal code. The 12 was added as an amendment to this bill on the floor. That is not a part of the federal regulations.
Was it another age before, or was that whole section?
That whole sentence on line 44 was added to this bill on the floor of the Senate.
Okay. Do you have any strong feelings about the age of 12 or why that was added? Seems to me that it should be 18. I mean, we're talking about school age children. The difference between a 12-year-old and a 13-year-old and the caregiver responsibilities, I'm not really sure what that difference would be to make it 12 instead of 18.
I think that at some point in time, as the children get older, maybe beyond 12, 13, that they're able to participate more in after-school programs at times when adult training might be going on, and so it was felt that there are resources available to provide for the older children that are still dependents.
Do you have an objection to changing that to 18, or maybe 16 at least when you might drive? I just don't see the difference between. I can see maybe there's a difference between 12 and 18 or 12 and 16, but 12, 13, 14, to me, if we're worried about a caregiver of a 12-year-old, we should be worried about a caregiver of a 13 and at least a 14-year-old.
I can see, 14 or 16 certainly. I understand what you're saying, and that was one of the concerns that was articulated on the Senate floor, but the amendment that was offered had 12, and we didn't make further changes, but I would hesitate to go above 16.
Okay. And then one final question. I know that folks who receive unemployment insurance, you've got them as being exempt from this, and I understand that. I think what your intention is you're not trying to target those who are, well, I won't, let me just start over. There may be folks, and I don't know that I could draw out this scenario, but I can envision a situation where someone might be seeking food stamps who is temporarily down on their luck. Maybe they're self-employed and their company goes under, something like that. They wouldn't, or maybe they do qualify for unemployment insurance, but for they choose not to do it, but they're like, well, I do need to feed my family and I go get food stamps. But in order to be exempt from this law where they've got to go and do these self-improvement courses, we might be encouraging people to go on unemployment who might not otherwise go on unemployment. Do you haven't share that concern?
No, I think if someone doesn't want to be on unemployment, I don't necessarily see that as an issue. I mean, but then again, if someone is eligible for food stamps and perhaps they needed to, and they're not working, and there were a way to receive some additional training or to prepare them or qualify them for a different job, I don't see that as necessarily an objection.
No, I'm just worried that we may be creating incentives, unintended consequences, where we're encouraging people who might not otherwise go on unemployment, to avoid the inconvenience of having to go to these self-improvement classes.
I don't have any numbers, but I would suspect that most people who are eligible for unemployment are going to receive that benefit, because certainly, they've, as a part of their employment, funds were paid in for them to receive that unemployment benefit.
But you do understand that you have to actually apply for unemployment, right. And there are many people who, even though they lose their job through no fault of their own, they choose not to go to the unemployment office and apply for it for whatever reason.
There may be a few that would do that, but I don't see that as creating a tidal wave of applications for unemployment benefits.
Okay, thank you.
Chairman Powell.
Thank you, Mr. Chairman. Does this anticipate that before somebody is required to work on professional development activities that there has to be some kind of assessment? I mean, as a practical matter, you know, if somebody has a high school diploma, you aren't going to require them to take GED. If somebody already has a skill or a trade, I presume you wouldn't require them to go to technical school. So rather than saying everybody has to do all of this stuff, you would do some kind of assessment first?
Absolutely. And again, the department does have certain, I guess, self-development classes now, and there's a process that would be used to evaluate, you know, where you should go and what you should do. You're right. If someone has a high school diploma, you don't want to send them to get their GED, and that is certainly not the intent of the bill, just to send people places for the sake of sending them for training in something that they already know. So I would think that would be part of the program, that you would be assessed, and if you could improve your literacy skills, then you could go to a class that would help you improve that. If you need your GED, or then you could go to classes to receive your GED.
Okay.
Representative Stevenson.
Thank you. Actually, Representative Powell started the conversation, and I wanted to go back on lines 12 through 16 as we discussed yesterday.
Right.
And it may be starting with line 12 that the eligibility comes after the risk assessment, because my reading of 14 through 16 may include, but not limited to, that all of the professional developmental activities after that point may not even be included in rules adopted by an entity or any of the 4 pilot programs. Am I right?
I'm not exactly following you. I'm sorry.
If on starts on line 13, it says, which may include but not be limited to working toward a general education development diploma. If the department's rules don't include that, because it may include, it's permissive, it's not mandatory, you haven't set forth a core based on a risk assessment. You've just set forth examples of what types of activities would come without the risk assessment. And it may not include any that's set forth on lines 14 to 16.
Sir, if you're suggesting that we change the word may to shall, I mean, we could, but I think we wanted to provide some direction, but at the same time have some flexibility within the program.
I agree that the activity should go with the assessment of what the person needs.
Right.
So it has to be an assessment first, and then determine what, if any, because it may be that the person has grown and meets the social responsibility except for being unemployed and then have food stamps.
Right.
And then that would, but I would think you would want a core that everyone should have. And yesterday I believe you said that was the self-development classes that at least one county has.
Right.
And I don't know what your core would be, but I would think the wording of 12 through 16 needs to be worked on.
Well, if you look at lines 17 and 18, we do give
the department
some discretion in promulgating the rules and the regulations to implement the requirements of the code section. And I think that gives them the ability to look at the different programs that they offer, and including their classes where someone could go get a GED if they don't have that. They have their own self-development classes within the department that they administer. And so then they would be able to have the rules to craft to say, okay, well, you meet these requirements, so now you need to work on your GED.
I'm not going to continue to answer, but I think when the department is given the authority to develop what the programs are without having some direction, it may not include what you keep saying regarding adult literacy. So that's my concern, Mr. Chair, and I thank you for your response.
Further questions from the committee? Seeing none, Senator Wiggin, thank you for presenting the bill. I've got one person signed up to speak, and then we'll take the bill under consideration. Viola Davis.
Viola Davis with the Unhappy Taxpayer and Voter. I was going to speak particularly bringing up the refugee situation here in Clarkston, dealing with this bill. But after listening to the gentleman speak, I said I needed to make it a little more human. I am a critical care nurse, and I have to tell you, I found myself in a situation where my sister died, and I had to raise my nephew. I had 2 family members that were veterans that lost their homes. They had to move in with me. I have a mentally ill nephew walking the streets. He had to move in with me. You talking about a perfect storm. That's the life some of us have out here. I am a critical care nurse with a bachelor's degree and found myself on food stamps. So when you talk about development, do you know how embarrassing it is to stand in a food stamp line? Do you think people want to do that? I am a veteran that served my country. I serve my community. And you would write these kind of bills. My father is a Vietnam vet trying to save his home. My brother served in Desert Storm and lost his home and now live in mine. It's embarrassing enough to stand in that line. Don't do this. Because there's a lot of us out there that have bachelor's and master's degree. That we have to survive because we carrying our whole family on our shoulders. This is only going to make it more embarrassing. And yes, when I lost my job, I should have been able to get unemployment. I started working in junior high in the fields of Texas, cotton fields of Texas. I have never been unemployed. Never. Until last year, and found myself where everybody was depending on me and I did not have a job and had wiped out all my savings. When you think about doing this, look at this face. This is an example of what misery is going on out there. I came to talk about refugees because they have it worse than I do. You are creating a perfect storm. And you're not going to realize it until it's too late. Don't do this.
All right. Does anyone else want to speak to Senate Bill 312? Yes, sir. Representative Bruce.
You know, I apologize if this offends anyone, but I just want to respond to that young lady. Ms. Davis, you represent a lot of people And that's what I was trying to say earlier with the questions I was asking. There are people that are very well educated that have, you know, committed themselves to trying to take care of their families and trying to do a lot of things. And I understand exactly what you were saying, and I just felt a need to, I can't reach over there and hug you, but I wish I could. And, but anyway, I understand what you're saying, and I support what you're saying.
All right. I'm going to suspend on the bill for a second, and allow Senator Gooch to present his bill quickly. Get him taken care of, and then we'll come back to this one.
Hopefully mine won't be too controversial. 257 is a bill that we believe helps development authorities throughout the state. You have development authorities, downtown development authorities, and regional authorities all over the state that are trying to create jobs, bringing industry to Georgia. The only thing this bill does is that requires members of development authorities that are reappointed to go back and take an 8-hour class to get updated on current events, current incentives that are offered by the state. It also gives them some opportunity to learn from their peers, see what other things are going on around the state they may learn from and take back to their home communities. So with that, I'll ask if you have any questions.
Questions for Senator Gooch? Chairman Powell.
What kind of comment have you gotten from maybe rural development authorities on this proposed legislation? And the reason I ask is I come from a rural area, and you're dealing with volunteers, and a lot of times you're dealing from a very limited pool of applicants. And to get volunteers to serve and serve seriously on such an authority, and then ask them to, because that kind of training's not available locally, so you've got to go to Tifton or to Macon or to Atlanta or to Savannah to receive that training for maybe 2 days. It's tough to get people not only to agree to serve, but then to agree to go to the training. And I think it's laudable, but might we not be hurting some of these authorities?
I'd be glad to answer that. It's a good question. These classes are now taught all over the state through the Fanning Institute. DCA helps promote these throughout the regions. It's not just Atlanta, not just Savannah, or not just in the mountains. They're scattered out throughout the state throughout the year. I'll remind you, too, that development authorities can do things that county commissioners can't do. They can borrow money, they can issue bonds, they can buy land, lease land, give away land, build industrial parks. They can abate taxes for schools, cities, and counties. They can join with other authorities, even in other states, to create industrial parks and things of that nature. When they have that kind of ability to leverage debt, I think it's important that these members know what the consequences are on some of these issues and what the new current laws are. The association that we all belong to is in support of this. I'm the director of the Development Authority for Lumpkin County. My board members are all going to school on their first initial appointment, and then as they get reappointed, if they get reappointed, they'll go back for an update. Some of them haven't been back in maybe 10 years because they've been on the boards for so long. And another provision in this bill, if you're looking at line 33 through 35, it says that if you don't get the recertification, that you just cannot serve as an officer of the authority. It doesn't mean that you can't continue to serve. You just can't serve as an officer of that authority. And those are the ones who are usually binding the authorities and signing the leases or the contracts for the debt. So.
All right. So the additional 8 hours of advanced training is not absolutely mandatory for service. It's just mandatory if you want to be an officer.
That's correct.
Thank you.
Representative Oliver.
Forgive me for not remembering this accurately, but this is the bill that had the provision in relation to meetings electronically being held?
No.
Okay. Okay. Forgive me. Thank you.
Further questions for the author? Seeing none, thank you for presenting the bill,
Yes,
Senator
sir. Thank
Gooch.
you.
Anyone else signed up to speak on, or does anyone else want to speak to Senate Bill 257? Seeing none, we'll close off discussion on the bill. The bill is now in the hands of the committee. Is there a motion? There's a motion and a second. Second. A motion and a second. And that's by committee substitute LC 295282S, correct? Yes. All right. Any amendments? Any amendments? Hearing none. Any discussion on the bill? Hearing none, the chair calls the question on the bill. That's to give a due pass recommendation to Senate Bill 257 LC 295282S. All those in favor say aye. Aye. All those opposed, no. The bill receives a due pass recommendation. Thank you, Senator Gooch.
Representative Jaspers will be carrying the bill.
Thank you. No problem.
Can we reconsider our vote?
All right, Senate Bill 312. Senator Wiggin, if you're welcome to join us again. All right. Any further questions for the author? Seeing none, we'll go ahead and close off discussion on the bill. Is there a motion on Senate Bill 312? There's a motion, and I assume one of those will become a second? There's a motion and a second. And that's by committee substitute LC 295277S. All right. Are there any amendments? Representative Evans.
I move that we amend line 44 to change 12 years of age to 16 years of age.
There's a motion and a second on that amendment to change 12 years of age to 16 years. You said 16 years of age on line 44. And any discussion on the amendment? Seeing none, the chair calls the question on the Evans amendment. All those in favor say aye. Aye. All those opposed, no. No. The amendment carries. Any further amendments? Any further discussion on the bill? Seeing none, the chair calls the question. That's to give a due pass recommendation to Senate Bill 312 by committee substitute LC 295277S as amended by the Judiciary Committee. All those in favor say aye. Aye. All those opposed, no. No. Chair is in doubt. The chair calls for a division of the House. All those in favor, raise your right hand. All those opposed, no. Chair votes in the affirmative. The bill moves forward with a due pass recommendation.
Thank you, Mr. Chairman.
Terrible.
Senator Albers.
Thank you, Mr. Chairman. I've already testified, so I think you just leave it to those who want to speak to the bill today. I won't take any more of your valuable time. But I can give it a third time if you really would like.
No. All right, and I do want to note, again, we do have two versions of the bill in folders. There's a committee substitute, LC 295237 ERS, and then there is the version of the bill that passed the Senate. What I'm going to do, because we have heard this bill several times between full committee and subcommittee, is I'm going to recognize anyone who wants to say anything about the bill very, very briefly to stand up from their seats and address the committee, and we'll move through it quickly that way. So why don't we just kind of start over here? Anyone? All right. Moving this way. Ms. Lowe. Moving this way. Wendell, you may want to...
From behind the post. My name is Wendell Phillips, public policy advocate for the Presbytery of Greater Atlanta, which is a governing body of the Presbyterian Church USA, and specifically working with the Public Policy Advocacy strongly opposed to both versions of the bill.
All right. Thank you, Mr. Phillips. Moving this way. Yes, ma'am. Everyone's together. Okay.
Melanie McNeil, the State Luncheon Care Ombudsman. Catherine Fowler, Georgia Council on Aging Director. Nancy Petro, the Senior Citizen Advocacy Project Coordinator for the AAAs and for the Council and for the Georgia College Society. We're just asking that I think we have a version of an amendment for each of the bills that would exempt that small group of folks that are either in personal care homes, skilled nursing facilities, or on Medicaid programs, home community-based services programs for long-term care services and support. Just ask that you carve them out. It's a small carve out. We've talked with the sponsor about it. And actually talked with our Senate partner too. So just ask that you consider that amendment there.
These are people who are either in institutional settings or are nursing home eligible. They're heavily case managed already, and feel like they're receiving an oversight that's needed.
They do have a lot of doctor, social worker, nurse oversight. There's going to be very few of them that are going to be getting $10 per film. There may be, and so we'd like to see them not get caught up in this unnecessary process.
Thank you. Ms. Yeager.
My concern isn't to these people who are dual diagnosed, which is about 50% of the population who has mental health.
Thank you, Ms. Yeager, Ms. Davis, and Ms. Bozeman-Davis.
For me, like I stated before, we're giving the numbers into consideration. We refugee population, because we have 18,000 plus that come to Georgia, and over 12 to 13,000 is in DeKalb County, particularly Clarksville. And what we're worried about is that a number of the people would possibly use their assistance, and with the different languages and so forth, there's no support system to catch those people if they get placed on the assistance. So what are we to do?
Anyone over? Yes, ma'am?
Yeah, I have a concern for the children and what happens with the children on school today.
Anyone else over here? Yes, Ms. Centerfit. I know Judge Goslin doesn't want to speak to the bill. So, all right, so that's anyone else want to rise and speak from their place? Seeing none, we'll go ahead and close off discussion on the bill. The bill is now in the hands of the committee. There's a motion, or I'll accept a motion. Chairman Lane, you're recognized.
I move to pass Senate Bill 292 by committee substitute as shown in LC 295237 ERS.
Okay, there's a motion due pass by committee substitute. Is there a second on that motion? There's a motion and a second. Discussion on the motion. Chairman, I'm sorry, Representative Dobbs.
Thank you, Mr. Chairman. We do have some amendments at the proper time, but I also wanted to ask, and I'm sorry I let the time go by, that we have representatives from the department here that we wanted to ask some questions to regarding some of the issues that were sort of unanswered, and we were wondering whether or not it's possible for them to come and answer some questions of members of the committee.
I will, obviously we wanted to move through testimony relatively quickly, being that we've been through testimony on one version or another of this bill in both subcommittee and full committee pretty quickly, or several times. But I will recognize someone from the department to come forward and answer questions from members of the subcommittee.
Thank you.
Right. Thank you.
Thank you.
Good afternoon. I'm Cliff O'Connor. I'm the fiscal officer with the Department of Family and Children Services. The department has no position on the bill, but we're certainly glad to answer any questions that we could.
All right. Representative Dobbs, you're recognized to ask questions.
Thank you. I've got a few questions. There was some discussion about exactly how much federal funding was involved in these TANF dollars. Can you explain that to us, exactly how much federal and how much state dollars go into the actual monies that are distributed to these recipients?
The cash assistance is budgeted under a program budget that you'll see in the state appropriation. It's called Support for Needy Families Basic Assistance. The appropriation is $52,400,415. Of that appropriation, all but $100,000 is TANF funds. So it's 99.8% TANF funding and 0.2% state funding.
So 98.8% are federal dollars.
Correct.
And only 2% are state. Okay.
0.2%.
0.2%. And then also, how much do you expect that it's going to cost to change the DHR computer system to actually handle these drug testing costs and having to change the way that you allocate benefits to those that do not pass the test?
At one point, we had looked at the original House version of this bill, and it was about $200,000. But now that we're reverting to what was the Senate version of the bill, there's no estimated cost for the computer system for the version that was passed in the Senate.
Okay, I think we are going on the House version. Is that correct, Mr. Chairman?
That's correct.
We are. So it's the House version. So you're thinking it's about $200,000?
There was I don't have the bill in front of me, but one of the bills had a provision where the drug test would be recouped from the client over
Yes.
12 months. If that's the version you have before you, there was a estimate done internally in the agency that would take $200,000 to reprogram our computer system for that.
Okay, I think that is the version that's in front of the committee at this point. I also have I'm sorry. And then my next question is have any additional funds been included in the budget this year to cover those additional costs of the program? I understand that now this bill is actually not going to go into effect until 2013, but this will require the department to ask for additional funds. Is that correct?
There has been no fiscal change to the budget based on this bill at this time, no.
Okay. Also, I know that when we lose federal TANF dollars, does that impact the state on any other dollars that are transmitted to us from Washington?
Not automatically, no. The total TANF block grant is $330 million, and the state has pretty wide discretion to spend that within certain federal rules. Whenever we lose TANF funding, the state has to make a policy decision through the budget process whether or not to replace that with state funds. So it's really fairly situation specific.
Okay, because I was under the impression that in 2013 we lost almost $9 million in funding for drug treatment because of lost federal TANF funds.
There was a reduction in TANF funding of $37 million in the last year from the federal government, and through the budget process there's been a mix of program cuts and replacements with state funds for what used to be funded with TANF to make up that $37 million.
Okay, thank you.
I'm
sorry. Go ahead.
No,
I'd be happy to share, yield and share the opportunity for others to ask.
I don't think you'll mind sharing it with Representative Oliver.
Victims of domestic violence are TANF recipients, are they not?
They are potentially.
If they go into a shelter, is that where they receive TANF funds?
The cash assistance is not dependent upon being in a shelter, but there is also TANF funding that goes to the family violence agencies through the family violence program budget. That's not based upon an individual eligibility, the financial criteria. It's based upon the situation of family violence occurring.
How many domestic violence victims are there in Georgia annually paid for by TANF monies?
I'm not sure I could provide those statistics, Representative.
Do you have any idea then how those unknown numbers of people would receive or take their drug test when they're being taken to a shelter in the middle of the night by law enforcement officers?
Normally the client or their representative would still have to interact with the local DFACS office in terms of processing their application and processing and collecting all the information required to establish TANF eligibility. So whether they're in a family violence shelter or not, at some point we need to contact that person and collect all the information to determine eligibility.
If they're in a shelter, they're not receiving a check, are they?
They could potentially be receiving a check, but not always.
Always. So if they're not receiving a check, there's no way for the state to recover that money if they're in the shelter. from deducted from any kind of non-existent check. Is that correct?
That's correct, in terms of we treat the cash assistance separately from the TANF money that we're given to the family violence shelters. The cash assistance runs through the individual eligibility process, whereas the money that we give to the family violence agencies is not on a client-specific basis.
Thank you.
Further questions? Representative Bruce.
So based on what I think I heard you say just now, the stated purpose of saving the state money by doing what this bill proposes is not going to save the state anything, is what I think I heard you just say, in essence. In fact, it may very well cost the state to implement this program. I know you don't want to answer that, but
I'm good at statistics. The 99.8% is the portion of the TANF cash assistance that was paid for with TANF federal funding.
Okay, well, we're saying the same thing. And so if the stated reason for doing this is negated by all the facts, and I know you can't answer this, and I probably shouldn't even ask, I'm being rhetorical, there's absolutely no reason for this bill to go forward. There's absolutely no reason for this bill to go forward based on its intended purpose.
Majority Whip.
No, I saw the blinking lights. So I'm not gonna. I saw my warning. I'll pass.
Representative Stevenson.
That was a good Lord working with me on that.
Okay, question. The $200,000 I think you mentioned as the cost, administrative costs that related to computers.
Mm-hmm.
What is the estimated department's cost as it relates to the individual appeal rights of the recipients?
There have been estimates that it could cost a couple $100,000 in terms of processing fair hearings. A lot of it would depend upon the volume, which is somewhat speculative at this point because we're not quite sure how many people would appeal.
Okay. And that's another $200,000 in addition to the $200,000 for the computer changes.
Yeah, we would normally pay for any administrative hearings on TANF with TANF funds.
Okay. So then we're talking about $500,000 potentially.
For those two items, yes.
Okay. Thank you.
Further questions for the witness? Seeing none, thank you for answering questions of the committee. All right. We have a motion under consideration. I'm not. Well, I'm not going to recognize you for that purpose, Representative Oliver. I will take amendments at this time. If anyone has any amendments, Representative Bruce.
Yeah. There's a under what is this? Lines 34. Excuse me, lines 34.
Line 34.
48. 69, 71, 73,
All right,
and 81.
Why don't we start by saying what you're going to replace or what you're going to change?
What's the matter?
And then we can go to lines.
Yeah. Yeah. It's an amendment to change the word person or to replace the word person with parent on those lines that I just stated.
Okay. Do we have copies of this? All right. Everybody, all right. It's been pointed out to me that we all have copies of these amendments in folders. So it's apparently a stapled packet, and it runs from AM 2005 through AM 2010.
Yes.
And the first one is this AM 29-2005, correct?
Yes.
All right. Is there a second on that amendment? There is a second. Discussion on the amendment. Are these, I've got all kinds of lights. Are these amendments or discussion on the amendment? Any? Legitimate question. Majority Whip.
That's a change. I'm sorry. My bad.
All right, Edward. 8, 9, 10. I counted to 10. And what's the purpose of the amendment? If you
It's we've been talking about parents throughout this whole discussion, and then we changed the word to persons. So somebody else.
Is that?
You want me to?
Yeah.
No, you may further discussion. Okay.
Yeah.
I really do just want to know what.
Representative Stevens.
I believe I know the reason why you would replace person with parent is because we're talking about the applicant in terms of being a parent rather than the person, and it would clarify the language where the definition is applied to. If I understand that there's going to be further amendments that limit the institutional population out of this bill, that's not going to be included. So we would be talking about parents.
All right. Further discussion on the amendment. Representative Evans, what's your? Oh, you wouldn't know, would you? 15? Are you on?
I don't.
You are.
I think I'm on. Just quickly, I think this amendment could also be called the "Don't Test My Grandma" amendment. I mean, we know that there are a lot of non-custodial parents who take in children, and there was a lot of discussion. I was away when this bill was originally discussed on the floor, but I was watching y'all from my computer screen, and there was a lot of testimony about how we wanted to make sure that we were protecting the children, and this amendment does exactly that. It protects children who may be under the care of people who are not their parents. They're taken in by grandparents and by aunts, and we don't want to create burdens for these great Samaritans who are taking in children who desperately need to be cared for by subjecting them to these tests when they're simply trying to take care of the least of our children who are out there.
Any further discussion on the amendment? Majority Whip.
Well, now that's been explained to me. Basically what this does is create a loophole. What we're trying to do is deal with folks who have custodial control over a child, and you are, by this amendment, taking out a fair number of folks who have custodial control over the parent, over the child, and so you're just creating a loophole.
Further discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor of the amendment say aye. Aye. All those opposed, no. Chair calls for division of the House. All those in favor, raise your right hand. 1, 2, 3, 4, 5. All those opposed? The chair, it's a 5-5 vote. The chair votes in the negative. The amendment fails. Further amendments. Representative Dobbs. Is that there was a letter-sized page.
Well, there was one that
This?
I thought was passed out this big size, but it is on that short piece of paper that you may have also, and it is the top one.
I'm being advised that we don't have the 20241. If we can get Mr. Allen, if you can get a copy of the short of the 8.5 by 11 page, Mr. Allen, I just want to be sure that it lines up properly with the bill, and then if it does, we'll consider it.
I thought it was passed out. I'm sorry.
Take that around, Miss.
I have it, but I'm not sure why nobody else has it. It's AM 292024. It's that Ms. Travis drafted for us. Oh, you want to make a copy of it? Okay. But we can discuss it. The only change from what you have on this short sheet at the top is that it's instead of it saying subsection M, this section, it should be this code section. But the amendment, Mr. Chairman, that I'd like to offer would be after line 115 on page 4, add the following. Subsection M. This code section shall not apply to individuals receiving long-term services and supports through a non-Medicaid home and community-based services program, a Medicaid waiver program, or in a facility such as a nursing home, comma, personal care home, comma, assisted living communities, comma, intermediate care facilities for the mentally retarded, comma, community living arrangements, comma, or host home, period.
All right, and is that to place that language in two places in the bill or one? I've got it in two places here.
No, it's just one. That bottom one was the Senate bill.
Oh, I see. Okay, right. Okay, there's a motion and a second, and the only difference between what you just read and what's on the page here is this code section.
That's correct.
All right. Does anyone want to speak to the amendment? Raise your hand and I'll recognize you. Seeing none, the chair calls the question on the amendment. All those in favor of the Dobbs amendment say aye. Aye. All those opposed, no.
No.
The chair is in doubt. The chair calls for a division of the House. All those in favor, raise your right hand. All those opposed, no. Raise your right hand, sorry. It passes.
Thank you, Mr. Chairman. I
Any-
have another amendment.
All right. Dobbs amendment number 2. State your amendment.
This amendment should be in the packet of long amendments. It would be on amendment of, well, actually there are 2 amendments on this page. It's AM 292010.
Hold on. We'll suspend for a minute. All right, I'll ask the committee to come to order, please. I'm going to ask the committee to come to order. All right. Dobbs amendment number 2.
Okay. It would be amending the substitute to SB 292, LC 295237 ERS by replacing line 62 and 64 as follows. If the applicant or a recipient fails the drug test in order to qualify for plan of benefits, the applicant or a recipient shall complete a drug rehabilitation program provided by the department, and within 6 months of testing positive, the applicant or recipient shall retake the drug test. At that time, if the applicant or recipient fails the drug test, the department shall apply a plan of benefits to the applicant or recipient.
All right, so that's AM 29, 2010.
That's correct.
All right. Is there a second on the amendment? There is a second on the amendment. Any discussion on the amendment? I've got a number of lights on, so I'll get folks to raise their hand if there's discussion on the amendment. Seeing none, the chair calls the question on the amendment. All those in favor say aye. Aye. All those opposed, no.
No.
In the opinion of the chair, the amendment fails.
Can we take a vote like we did on all the rest?
All right, I'll call for a division of the House. All those in favor, raise your right hand. All those opposed. The amendment fails. Further amendments. Representative Oliver.
On page 2 of 295337 ERS, line 54, after the word older and before the period, I wish to offer the following amendment, comma, except individuals who are receiving TANF benefits based on being victims of domestic violence. The purpose of my amendment is to exclude from this drug testing the domestic violence who, through no action on her own, is receiving assistance in order not to be harmed or killed by her spouse or partner.
All right. Yeah, can you state the amendment just one more time?
Yes, sir. On page 2, line 54, after the word older, I offer the following amendment prior to the period, comma, excluding individuals who are receiving TANF benefits based on being victims of domestic violence.
Is there a, Mr. Allen, do you have the amendment?
I will just say, Mr. Chairman, in support of the amendment, that it's an act of social responsibility to seek assistance as opposed to a failure of social responsibility to stay in an abusive home.
May I read it back? I'm sure.
Certainly. Mr. Allen, if you can pull your mic to you.
As I have the amendment is on line 54, before the period, after the word older, comma, excluding individuals who are receiving TANF benefits based on being victims of domestic violence. Is that correct?
Yes, sir.
Thank you.
Is there a second on the amendment? There is a second. Any discussion on the amendment? Raise your hand, because I've got folks on for amendments and folks on to discuss. Majority Whip.
A question to the author of the amendment. My understanding of the testimony we heard earlier, and correct me if I'm wrong, was that the money generally goes to the shelter to run the shelter rather than to the individual. And so my question is this, that money would not be affected by drug testing. That's my understanding. Now, am I right? Am I wrong? I just need, honestly, just need clarification on that point. And I'm more than happy to if with the chair's permission, to have the individual from the state agency sort of clarify that. If it's money going to the shelter, then that's not going to be money that's going to be impacted one way or the other by this bill. But if it is, then I'm more than willing to consider your amendment. I want clarification, I guess.
I think that's a really good question, because throughout the questioning I've had of the author, and to follow up Mr. O'Connor, victims of domestic violence are recipient of TANF services. Now, the author said that he wanted them to be included. That was his intent, because they were receiving taxpayer money. I believe, and he can correct me, of course. Mr. Connor's testimony was on both sides. He said the money was going to the shelter, but sometimes it goes to the victim.
I guess
Did I hear that right?
I just need clarification on that.
And I think it's a really good question. But I will say this in response in general.
Yeah.
I don't want victims of domestic violence, whether or not however the taxpayer money is being paid, either to the shelter or to the victim, to result in a decision by Mr. O'Connor's agency that they have to test all.
Like I said, I want to let's give, and I don't mean to cut you. I just want to know where the money's going.
Fair question.
If I could get some clarification.
Yes, sir. Mr. O'Connor, right? Come on forward.
Thank you, Mr. Chairman, for indulging me.
And actually, just to make this administratively easier, why don't you hang out in that chair in case there are further questions. It'll keep things moving efficiently. Go ahead, Mr. O'Connor.
I think what can be causing some confusion is that TANF is used in several different ways. It's my belief that most of this legislation is really talking about the TANF cash assistance. The TANF cash assistance is the $52 million a year that we put out. In order to access that cash assistance, DFEX has to actually come in contact with the client, process an individual application. That client may or may not be a victim of domestic violence. So whether or not that person lives at a domestic violence shelter is irrelevant to us in terms of determining their TANF eligibility. Separate from that, we do use TANF funding. In the adopted budget this year, it was $10 million in TANF funding, where we directly contract with a series of family violence agencies across the state. From our viewpoint, that money is not going to the clients, it is going to the family violence shelters. Those shelters therefore use that money to help support their costs to serve family violence victims, whether or not they are receiving TANF cash assistance.
I think I heard him correct, Mr. Whip. But the language of line 54 is applicants for TANF assistance, and I'm suggesting that would include, in the definition, ladies who live in shelters, that they would be TANF, and that was the author's intent, that they be, based on his testimony last time.
Could we read back the proposed amendment?
All right, Mr. Allen.
With the chair's permission.
That's fine. Mr. Allen, can you read the amendment back, please?
Yes, sir. On line 54, near the end, after the word older, before the period, insert the following, comma, excluding individuals who are receiving TANF benefits based on being victims of domestic violence.
Would the author of the amendment be willing to add a language there, and are residing in a domestic shelter?
Yes, sir.
If I could ask for that friendly amendment.
All right. Will you accept that as a friendly amendment to
Yes,
your
sir.
amendment? All right. So we'll
It's
incorporate.
semi-friendly, but yes, sir.
Right. Let's read. Okay. Mr. Allen, do you have that? Yes. Okay. Any further discussion on the amendment as amended, which is what we'll vote on? Chairman Powell.
I think what I heard the whip say, and I don't know if Legislative Council wrote it down exactly, he said domestic shelter, not a domestic violence shelter. Yeah, domestic violence shelter.
Without objection, we'll go ahead and incorporate that into the amendment as amended. Representative Welch, did you waive? All right. Anyone else want to speak to the amendment? Before we vote on the amendment, I'll recognize Mr. Allen one more time to read back the amendment.
Yes, sir. Line 54, after the word older before the period, insert the following, comma, excluding individuals who are receiving TANF benefits based on being victims of domestic violence and are residing in a domestic violence shelter.
Chair calls the question on the amendment. The amendment as amended with the friendly Lindsay amendment. All those in favor say aye. All those opposed, no. The amendment carries. Further amendments? I've got. You may, Representative Stevenson.
Thank you. Could you explain to us, because we heard testimony regarding the refugees, which is a huge problem in DeKalb, how do they receive the TANF benefits and what amounts during the resettlement process?
The federal government makes available to us assistance to refugees, and one of the ways is cash assistance. And the way they've structured that program is it basically mimics the TANF eligibility rules. Well, for a certain time period, we will give a refugee what's really a refugee cash assistance, but the same rules are typically followed for that as is followed for TANF cash assistance. And then when that time period expires, federal eligibility for refugee benefits ends, and the client either is or is not eligible for TANF cash assistance out of the TANF block grant.
Well, is your understanding of this bill, when you say mimic the TANF rules, would that capture the refugees in the resettlement process?
I would need to go back and research to be completely sure of my answer, Representative.
That's important if we are capturing 100% resettlement refugees.
Did you have any amendments, Representative
I do.
Stevenson?
I do.
You do? Well, you're
yes.
recognized now.
It is AM 29, 2006, and it is the substitute to Senate Bill 292. It's also on page 2, starting on line 54, but I'm going to read it, and it would include the amendment language, but this is the language. Testing program is in the package. Testing program for applicants of TANF benefits who are 18 years of age or older, who the Department of Human Service has reason to believe are using marijuana or controlled substances. And then on line 59, the same language. And that reason to believe is the more consistent constitutional statutory scheme.
All right. So this is AM 29, 2006 as it's in folders?
It is.
Okay. Okay. So exactly the way it appears in our folders is how you're proposing.
It's exactly the way on lines 54. And I said with the exception of having to include the amendment that we have now adopted that also affects line 54. So it's on line 54 and the change of the language on line 59 as set forth in AM 29-200.
All right. So let me make sure I understand this. You are looking to not do the amendment that's on lines 1 through 4, but you are looking to do the amendment. This amendment would be out of order having already placed an amendment in the same place. So, I mean, the only way we'd be able to entertain it is if you're I mean, we just amended the language on line 54 in the same location, so.
No, we amended it after the older. So we would insert it starts with testing, which is before the amendment started.
Mr. Allen?
I can weigh the two together if that's the wish of the committee. I think I see what you've got.
Well, I'll tell you what. We've got a couple of other folks with their lights on for amendments. If you want to work with Mr. Allen to try to make that work, I'll recognize you for the amendment.
I appreciate it because I can read it with the amendment we made, and I can work with you on writing it.
All right. Representative Evans.
Thank you, Mr. Chairman. I move, this is in your packets as well, AM 29, 2007, exactly as it's printed here, and the purpose of this amendment would be that the department would bear the cost of the drug test instead of the folks who are applying for benefits, and the act would only become effective if funds were available for this purpose. And I will add that when Senator Ligon was here earlier and we were asking him, or I was asking him whether the in his bill that would require food stamp recipients to engage in professional improvement activities, I asked him if the state would be paying for those activities, and he said yes, because the state has to. We can't require folks who are applying for these benefits to pay for services, and that's exactly the truth here, and that's why I moved this amendment.
All right, and that's AM 29, 2007. Yes. Is there a second on the amendment? Discussion on the amendment. Representative Hatfield.
I'd just like question to Representative Evans, what's the authority that you cite for that?
Mr. Ligon's testimony, I asked him if we were going to require conditions on food stamp recipients to engage in GED courses or other professional enhancement activities. I said, is it your intention that the state would pay for those enhancement activities? And he said yes, because it has to be. You can't place a condition on services that the recipient has to pay for, and so I would assume that has to be true here as well. And we can bring him in to cite to the authority, but I'm just citing your colleague, our colleague.
But we're talking about a different program, and I'm not aware of any authority that would stand for the proposition that we couldn't require the recipient to pay for that, and it's a minimal cost. You're not talking about a lot of money here.
If I may, Mr. Chairman, it may not be a lot of money to those of us sitting around the table, but when you're applying for benefits, that the maximum amount of benefits you can get is $280. I would submit that $40 is a lot of money. That's a pretty large percentage of $280, and I believe that we are putting a roadblock. I think we've got as a policy of a state to offer these benefits to those who need it, who need temporary assistance to get through rough times. And if we put a roadblock in front of them that's going to prevent them from even applying, then we are failing in our duty to our citizens to provide that social safety net. So in addition to the reason that I cited earlier, relying on Mr. Ligon's testimony, it's also to implement the purpose of TANF in the first place, which is to help those in need and not put roadblocks in front of them to get the need that we've set out for them.
All right. Any further discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. Aye. All those opposed, no. No. The amendment fails. Any further amendments? Representative Dobbs.
Thank you, Mr. Chairman. I have one more amendment, and it is actually listed on your sheet that is entitled AM 292010, and it would be replacing line 106 as follows. It would read 2 tests in a 2-year period, semicolon, and provided, comma, further, comma, that any recipient that passes the drug test shall not be charged for the cost of the drug test. And we've had lots of discussion about this. The intent of this bill is not to be punitive, and when you consider that the maximum amount of TANF dollars someone receives is $280 for someone who does not test positive, that this would be a huge
Representative Dobbs,
effect.
we have in the minutes that and I remember the amendment. I mean, we did this amendment
Have
already.
we done this amendment?
Yes, it was voted down 6-7.
Okay, thank you. Sorry. I have no further amendments.
All right. Any further amendments? Representative Welch waives. Any further amendments, Representative Stevenson?
Legislative Council has integrated the past amendment into my desire amendment on AM 292006, and if you could read it so that it can be read together, starting on line 54.
Mr. Allen.
I'm going to work off of AM 292006 and indicate the change there. On line 2 of that amendment, near the end of that line, after the word older, insert the following, comma, excluding individuals who are receiving TANF benefits based on being victims of domestic violence and are residing in a domestic violence shelter, comma.
All right. Let's repeat that one more time for the committee, Mr. Allen.
Working off of AM 292006, amend that amendment on line 2 of that amendment near the end, after the word older, insert the following phrase, comma, excluding individuals who are receiving TANF benefits based on being victims of domestic violence and are residing in a domestic violence shelter, comma.
All right. I'll let you, that technically that does amend in the same place we've considered a prior amendment. I will allow a consideration of the amendment, though.
Thank you.
All right. Is there a second on that amendment?
I second it.
There is a second. Discussion on that amendment.
I didn't get it all of the amendment. If you could just restate that.
We'll do that one more time. It's AM 29/2006.
Okay.
And Mr. Allen will read how that is revised.
I got that. I waive.
All right. Let's do it one more time, Mr. Allen, and then I'm going to call a vote.
On line 2 of that amendment, near the end, after the word older, insert the following phrase, comma, excluding individuals who are receiving TANF benefits based on being victims of domestic violence and are residing in a domestic violence shelter, comma.
All right. So this would be the language that would appear in that place in the substitute if this amendment is adopted. If not, the Oliver Lindsay amendment as it was proposed will stand the way it was. Okay. All those in favor say aye. The chair calls the question. All those in favor say aye.
Aye.
All those opposed, no.
No.
Chair's in doubt. Chair calls for a division of the House. All those in favor, raise your right hand. All those opposed. Fails on a vote of 6-8. Further amendments, Representative Evans.
Thank you, Mr. Chairman. This amendment, I think this must be a typo or something. So on line 59, in the sentence that starts a recipient of, it says a recipient of TANF benefits shall submit not less than once every 2 years to the department's random drug testing program, et cetera, et cetera. My amendment is to change the word less on line 59 to more, because I believe if it's saying you have to submit to a drug test not less than once every 2 years, that's requiring everyone to do it, and therefore it couldn't be random. I think it must mean you must not have to submit to random drug testing not more than once every 2 years.
Is there a second on the amendment?
Second.
There is a second. Any discussion on the amendment? Hearing none, the chair calls the question on the amendment. All those in favor say aye.
Aye.
All those opposed? No. Chair is in doubt. Chair calls for a division of the House. All those in favor, raise your right hand. All those opposed? The amendment carries on a vote of 8-6. Representative Hatfield.
Mr. Chairman, I'd like to move for reconsideration of that last vote.
There's a motion for reconsideration. Is there a second? Second. There's a motion for reconsideration. Any discussion on that motion?
Is it your? I'm sorry.
Mr. Chairman, I guess what I'm looking for some clarification, and to the author of the amendment. I mean, to the motion. Are we looking to require drug tests more often than once every 2 years, or less often than once every 2 years?
Well, I look at it in the context. It says not less than once every 2 years, so it's tied in with the 2-year period. I don't read it the same way that Representative Evans seemed to be reading it. That indicated that it would require everybody to submit. I read it to mean not less than once every 2 years, as opposed to.
I guess if I may, Mr. Chairman, inquire. I guess what you're getting at is, or would you be in agreement that what we're talking about here is trying to make sure that it takes place at least once every 2 years, but not more than that?
Correct.
Perhaps then maybe we can then support the motion to reconsider and then try to clean it up just a little bit more. With that in mind, I'm going to support the motion to reconsider and then try to.
All right.
Well, my question is
Representative Evans.
The question would be, if looking at the word random on line 60, it can't be a random test if every single person has to take it. And so when that's why I think it has to be more, because we're saying you can't be chosen at random more than once every 2 years. It's not the same thing as 292. 292 required everybody to get tested. This bill, Representative Hardin's bill, which was passed in the Senate, was for random drug testing, not for every recipient to be tested. So that's why I would urge my colleagues to vote against the motion for reconsideration, because I believe otherwise this will not make sense. You can't have a random test that everybody's required to take.
Well, I think
Representative Hatfield.
I would disagree with that. You could have a random test that everybody required to take. It's done at variable times when the person's not told ahead of time when it's going to be taken. So it can be completely random.
Right. I'm going to call the question on the motion to reconsider. All those in favor of reconsidering the Evans amendment say aye.
Aye.
All those opposed?
No.
Chair calls for a show of hands. All those in favor of the motion to reconsider, raise your right hand. All those opposed? The motion fails on a 6-7 vote, and the Evans amendment stands. Any further amendments? I've got a number of lights on, so I'm going to clear them out. Any further amendments? Seeing none, the chair calls the... Mr. Allen.
I just want to clarify on the amendment that was adopted and reconsideration has failed. On line 59, the word less has been changed to more. Is that correct? Is that correct?
That is correct. That was the amendment.
Thank you.
All right. Are there any further amendments? Seeing none, the chair calls the question on the bill. That is to give a due pass recommendation to Senate Bill 292 by committee substitute LC 295237 ERS as amended by the Judiciary Committee. All those in favor say aye. All those opposed? No. In the opinion of the chair, the ayes have it. The bill receives a due pass recommendation. All right, the final bill we have on the agenda is, lost the number, 34. Senate Bill 234. Chairman Willard and Senator Rogers are going to present that one. We'll allow a minute for folks to clear out of the room.
We want to
Representative
go
Bruce.
on record that there's a minority report going to go with that bill.
So noted.
It's a beautiful thing. Kind of looks like sausage. Yeah. Y'all got paid by the hour. You can turn this thing into a full-time gig.
We gotta keep up our habits.
All right. Go ahead, Roger. Whichever one of you speak more succinctly.
He and I have gone over it. He's got them marked down, and I think we're in good shape for him to comment.
Thank you,
I'm back.
Senator Rogers. We're pleased to have you. Appreciate your patience. We've got before us Senate Bill 234. I'd like you to explain the committee.
Thank you, Mr. Chairman. I will be very brief in my remarks. Then I'm going to let some of the experts talk more in depth about all the changes in the bill. But I want to tell you why we're here today and how this process has worked. For those who have served for quite some time, you know, we went through a battle a number of years ago, and it was an epic battle with a plan called the Great Plan. And that plan was to wipe away property taxes in their totality. Me and one other person that's no longer in this building took a lot of arrows on that, but I still think it's the right thing to do, but clearly the state wasn't prepared for that. So at the conclusion of the Great Plan failing, I said, you know, some of the frustration, a lot of the frustration built into the Great Plan that was being, or the Great Plan was set to address, is because people just don't understand the property tax system, and they feel like it's weighted against them. They feel like the whole system is against the taxpayer. And as you read the code, they were pretty much right. So a couple of years ago, we had a pretty comprehensive rewrite of the appeals and assessment process. In that, I made a lot of friends, and a lot of them are sitting in behind me today. And what we were able to do was to bring tax commissioners, tax assessors, tax attorneys, taxpayers themselves, ACCG and GMA, everybody who had an interest in property taxes, to form a roundtable group. And we kind of committed ourselves to year after year going through the entire code and finding those things that are problems that we can all agree on need to be corrected. And when you can get that group to all agree on something, you've done something pretty special. So this bill before you today is really a culmination of that process for the last 2 years. So while there are a lot of changes in here, I don't know that there's any change in here that's even merits being labeled controversial. So I'm going to let Roger Land, he is a tax attorney, he can certainly give his credentials, talk about all the changes that are in there. He, along with others, have helped lead this group over the last couple of years. I think what we have here is a very good piece of legislation. It will be difficult to go home and explain exactly what you did, but you can confidently say that you have improved the property tax system in a significant way on behalf of the taxpayers by making it simpler, more efficient, and more effective, and not so weighted in the way of government. So I'll let Roger Land explain all the changes in the bill.
All right, sir. Bring that around.
Mr. Chairman, Roger Land. As Senator Rogers said, I'm a tax attorney. I represent taxpayers all over the state of Georgia, large timber companies, agricultural interests, commercial interests, homeowners. And we've worked in our group, and we've worked with Senator Rogers now for a number of years. And the bill before you, which should be LC 295268 ERS if we're working off the same one, is a good bill and is a start on trying to improve the methodology and function and relationship between taxpayers' appeals and the tax assessors. And that's what this addresses. The first several sections deal with tax executions, and there is obviously need to tighten up the tax executions and the sale of those tax executions. Other than line 110, which says that if a transferee sends notice to the delinquent taxpayer, that happens to be regular mail, I would suggest certified mail or statutory overnight delivery. I think throughout this bill we've tried to give whoever the affected person is as much notice as possible. I personally have no confidence in the post office and prefer some type of evidence that it was actually done. So I would suggest in line 110 regular mail be changed to certified mail or statutory, as well as on line 115. And that is the duty of the transferee who has bought a tax execution. all the way through section 4 is tax assessment valuation. And the only thing that I know in there that's missing, Mr. Chairman, and I have seen an amendment, is that I believe in the original version of V12 that we furnished you with, if not in Senate Bill 234 as it came over, was a provision that if an appeal is filed, the tax lien cannot be sold until the appeal is
We got that for an amendment.
Thank you. It is a good amendment. The next thing, Mr. Chairman, is at the end of line 203.
Okay, I know what happened to it.
Mr. Chairman, at the end of line 203,
Yes, sir.
there was a sentence dropped out of V12. And what this is dealing with is throughout Georgia, but primarily South Georgia. Most of these tax assessors, when you have a revaluation, hire somebody to do it. They have no training. They have no licensing by the DOR. So the sentence was dropped at the end of 203, and what this is talking about is intergovernmental contracts that they can hire somebody. The sentence was dropped as such contracts shall only be entered into with persons who complete satisfactorily such training as directed by the commissioner.
Have you got that published?
It was at the end of V12 at line 62
I
and
understand.
64.
It's not in the bill now.
I
What you need to do is get that published so we can have it.
I will. I'll work
I think you'll have time to get something put together.
We'll do that. Where is that going to go? It'll go at the end of line 203 on page 6 of 5628 ERS. At the end of commissioner. It says in the rules and regulations of the commissioner.
Okay, after that.
Then there's a separate sentence that we'll write up, and it'll say such contracts shall only be entered into with persons who complete satisfactorily such training as directed by the commissioner. Skipping through the bill, which is explanatory and we believe protects and helps taxpayers' rights. We have input from the clerks of Superior Court. We wanted things inserted, the Tax Commission, the tax assessors, the ACCG, and coming to an agreement with that many different people is difficult. The next comment I have is on page 21. And to explain, it's a long code section, but basically Section E applies to all appeals, whether it's to an arbiter, to a hearing officer, or to the BOE. E.1 is just a hearing officer, and I believe we need to insert at the end of line 727 the identical language that I think is out of place in line 800. In line 800, number 10, and it'll be numbered the same. But line 800 says, within 10 days of final determination of value of the tax assessors, Board of Equalization, arbiter, hearing officer, Superior County Board of Taxation shall forward such decision to the tax commissioner. That just happened to get in the arbitration section. I believe it more correctly would be put at the end of 727, which would be the end of E, Mr. Chairman.
So you suggest in both places,
That it be,
Lanner.
that it be extracted, lines 800, 801, 802
Okay.
be extracted and put at the end of line 727.
As number 10?
Yes, sir,
All right.
as number 10. The next thing I have is we had this discussion. I don't know how anybody wants to treat it, but in line 803, it says each hearing officer should be compensated by the county for time expended in the appeals.
What line was that again? I'm sorry. I was trying to write
It
something.
starts at line 803.
All right.
Each hearing officer should be compensated by the county
Yes,
for time expended in considering appeals. I would add, other than agreement by the parties, if you had a complex appeal and the taxpayer and the assessors want to change the compensation, we think by agreement of the parties, they should have the right to do that.
May I suggest we do that on line 806 after the authority?
Yes, sir. That's good.
Okay.
Yes, sir.
Keep that in mind. Let's see. What you want to add in there is, or as may be agreed upon by the parties.
Yes, sir.
All right.
The next thing is at line 810, beginning with if the clerk of the Superior Court cannot find a qualified hearing officer, etc., down through 815.
Yes.
That is a duplication of the items between line 777 and 781, so I think it probably should be stricken, because we've already stated it in line 777 through 781.
All right.
And it's just a duplication.
What was that, Mr. Chairman?
Be it late 810, sentence beginning with the clerk of the Superior Court. All right, sir.
Mr. Chairman, beginning or in line 842, we've had a lot of problems with when the tax assessors get these notices of rejection out. And the language now is stated, beginning in 41, in the middle says a notice of the taxpayer shall within 45 days of the filing of the notice, date of transmittal. Something's gotten askew there, and I think you need to strike in 842 after the filing of the notice. Notice is already stricken, but shouldn't be filing of the date of transmittal. That doesn't make sense.
I'm not sure how we're going to correct that. I'm trying to read what we're trying to send it as far as date of transmittal of the acknowledgement.
Mr. Chairman,
yes,
should just read 45 days of the date of transmittal instead of 45 days of the...
What are they doing within 10 days, the taxpayer's notice of arbitration by the Board of Assessors and the taxpayer an acknowledgement of receipt of the appeal. Then a notice that the taxpayer shall, within 45 days of the filing of, which comes to another issue. I'm not sure what, of the notice?
The tax assessors send back a 10-day letter. We call
Provide the board. Okay.
Should say 45 days of the date of transmittal of the acknowledgement.
Yeah,
Yes,
45 days
yes,
of the date.
of transmittal of the acknowledgement.
So strike out of the filing of the notice. So
Yes.
strike out all that. That should all be.
Yes,
That's what it is. Okay. Then strike it up. Got you. Now we got it cleared. That's a good one.
all right, 851, this is still sort of the same type thing. After arbiter and within 45 days of, that filing the notice of appeal is incorrect now with the change, so it should be 45 days of the acknowledgement of receipt of the appeal.
And strike out from where?
I would strike filing the notice of appeal.
Filing the notice of appeal. Okay.
We're on
Line 851.
851.
So it will read, prior to the appointment of the arbitrator and within 45 days of the acknowledgement of the receipt of the appeal, comma,
Yes.
the taxpayer shall provide a copy of the certified appraisal, etc. Okay.
Yes, sir.
All right.
The next cleanup item I would suggest is on line 899 on page 26.
Page 26.
898. 899 is actually where the problem becomes. But starting at line 897, if the parties can't agree on a single arbiter, shall be chosen by the presiding or chief judge of the Superior Court of the circuit where it's located within 30 days. And this says after the date of the rejection of the taxpayer's appeal, a certified appraisal, which again I think we're going back to what we had before. So I would say within 30 days after the request by either party, which if you have a deadlock, either party can petition the judge to have a single arbiter appointed. But you can't have 45 days and 30 days in the same time frame.
So within 30 days after the filing,
We've already said the taxpayer's got 45 days after
we're
that.
filing something in court now.
Right.
What do we call what's being filed? The motion or hearing?
It says, only can I do the same. It just says the arbiter should be chosen. Well, somehow the judge has got to find out that the party wants a single arbiter appointed, and somebody's got to request it.
How's that coming to the court, is my question. How's that brought before the court?
Well,
by petition?
It'd have to be by motion or petition.
Has to be by petition.
By
because
petition.
the court's got to have original action.
Correct.
So within 30 days after the filing of a petition
Correct.
by either party.
Correct.
All right.
So we're going to take out date of rejection of taxpayer certified appraisal and insert filing of a petition by either party. Period.
It will read only if the parties cannot agree on the single arbitrator, the arbitrator shall be chosen by the presiding or chief judge of the Superior Court of the circuit in which the property is located within 30 days after the filing of a petition by either party. Period.
And we're just taking out date of rejection.
All that line. All line 89.9
Okay.
stricken. Anything else, Mr. Lane?
Yes, if I can get this phone cut off. On line 1004 on page 28. We've had a lot of consternation about the law puts the burden on the assessors to carry the burden of proof on the valuation to determine fair market value. Now, if the court finds that the tax assessors have failed to meet their burden of proof, line 1003 says, upon motion of sui sponte, authorize the finding that the value asserted by the taxpayer is unreasonable. That's been stricken and put reasonable. To me, that looks like it's just backwards, because if the court says that the burden has not been carried and the taxpayer is reasonable, then they'll enter the final value. But if they say the taxpayer is reasonable, you certainly wouldn't send it to the jury or the finder of the fact after that. So my recommendation would be to undelete.
The court does it. The court does it without it going to the jury.
Correct. That'd be
Like
finder
a
of fact.
yeah.
Wait a minute
So,
now.
hold on. Let's finish. You push a button and I'll recognize you, please. You're saying that what you have here is the court says you failed to meet your burden of proof, so you have in effect a directed verdict, or if you have no jury, you've got to go up with the motions called, but there is a manner of doing that. And that's probably what we try to assert there, something on that line. Mr. Weldon.
Why do we need the language in there, sua sponte? I mean, that's...
I understand. We're just trying to...
That just
Well, that
seems
means on its own
redundant.
motion.
Yes, sir. I mean, but that always, I mean, in a situation like that, I mean, this is...
Doesn't hurt, yeah. But either by a motion of the party or the court's making its own statement, you have failed to meet your burden. But be that as it may, I don't know if we use the term reasonable anyway. I think with finding that the value of the taxpayer is established as the true value of the property.
Yes, sir. That's correct. That explains it. Probably fair market value be in comparison?
The fair market value, the fair market, the true fair market.
Yes. True is used on
Yeah.
foreclosures.
And authorize the determination, and authorize this determination as a final value of the property. I don't think you need that on there. I think you just need to say, by the taxpayer established as the fair market value of the property, period.
Yes.
All right?
Mr. Chairman, that concludes my remarks.
Thank God. Thought we were rewriting the bill.
May I ask a question regarding that last one?
Push a button, if you would. Yes, sir.
I want to be clear as to what it is. I mean, it's obvious that if the tax assessors have not met their burden, that then you can basically discount that and authorize the determination of the final value. But are we saying that the taxpayer's proposed value then becomes determinative, whether it's reasonable or unreasonable? Or are we just saying that the court then can submit the issue? I'm not sure where we wound up on that.
I think you have a finding that they failed to meet their burden of proof. As with any civil issue, the failure of that burden not being met is a finding of, well, in this case, you got one value vis-a-vis the other value. So if they didn't meet their burden to prove the value, you have to fall back to the value of the taxpayer, would you not?
I don't know, because, I mean, conceivably the taxpayer could say my property is worth $1. I mean, so I don't know that you want to just say that that is the default position. Am I reading this wrong?
Well, it says the court may authorize a finding, they're permitted to make the finding of the value asserted by the taxpayer as being the fair market value of the property. Authorize, I guess, means there's still the option to do otherwise. It doesn't say it may direct. Like, my judge is nodding. So it says, upon the failure by the tax assessor to meet its burden, the court may authorize the finding that the value asserted by the taxpayer is reasonable and fair market value.
Yeah, it's just
is reasonable and is a fair market value.
Yeah, it's permissive, not mandatory,
Right.
Okay.
Let's do it that way. I got some more lights blinking. I think Mr. Welch.
No, you hit on it.
Okay, Mr. Hatfield.
Mr. Chairman, I was just going to say, do you think we would want to add another sentence there to say something along the lines of otherwise the court may proceed to make a determination of the fair value of the property?
Or the court may proceed to make a determination. What would they consider, I wonder, as far as evidence? How are they going to do that? What they're going to have before them is, like in a condemnation case, is a two-party seeking to establish a valuation, the burden being carried by the assessors, the property owner asserting his position. So I don't know what they're going to do otherwise.
Well, in the event, it's like Representative Powell brought up, that in the event that you've got an unreasonable amount being advocated for by the taxpayer, then would the court not then be in a position to take evidence, further evidence?
I think if I were sitting as a judge, I'm not sitting one anywhere, I would just say we've got a mistrial then. I can't accept your value because you failed to meet your burden and you don't have what I consider to be a reasonable valuation. You haven't carried your responsibility in response to it, so I'm just going to declare a mistrial and nothing's decided by the court. If they're authorized to do it, cannot meet that authorization, perform it, then where are they left?
But
Well,
in the
I
interest
just can't
of,
imagine that that would be the best outcome.
yeah,
of
in the interest of judicial economy, if that doesn't seem to make a whole lot of sense.
What are they going to do? Go out and determine their own value?
Order the parties to submit further evidence.
I guess the court can adjourn, but they can't just hold the trial up while they go out and try and pull something else together. This is during a civil trial. It's like a condemnation case. Same thing, any other civil trial. Who else over here?
A comment. I would find it highly unlikely that the court would reach an opinion that the board failed to carry its burden of proof if, in fact, the taxpayer has an unreasonable, because all that's going to have to be considered in the validity of the opinion. Is that correct? Because it can't end up with neither party. If one moves, if the taxpayer moves and says, you know, I win because you failed to carry your burden, and then the judge, could the judge decide that you win but you can't win?
I think no. I think the court. What we're saying here is the court may be authorized to accept the valuation established by the property owner. By maybe, the court can still say no. We don't think that's good evidence either. I'm just going to declare a mistrial, and you've got to go back and do. You, the assessor's got to go back and do either a reevaluation or redo the case. Go through the whole process again. More questions on this is coming up, I think. Mr. Weldon.
Well, in order for the court to make a determination that the tax assessor hasn't met their burden of proof of value, and then also, I mean, it just seems like just practical situation. I mean, how is a judge supposed to make a determination that neither party proved the value, but they don't know what the value is?
There are standards in the law as to what makes admissible evidence on an issue.
I don't.
Even as to valuation of property, there are standards that have to be met. As an example, I don't think the tax assessors just come in without a qualified appraiser and give testimony about the value, although the property owner probably could. The tax assessor's got to bring in a qualified appraiser and go through the process of having that person meet the needs under law, prove they're capable of making the determination or not. Now, if they fail to do that, then the court says that's your only witness, then you have failed to meet your burden.
So why wouldn't they take the the taxpayers?
Well, just say if the court also found the taxpayer has argued, well, my value, I say is $10. No, that's not reasonable either, and I'm not authorized to accept. I'm not accepting that because I've got the option of either accepting it or not.
So if they're going to make that decision, that determination that it's not reasonable, then they have to make a decision on what is reasonable.
They do not. What we're saying, there's no requirement. The court has to make a decision. None at all. Mr. Lindsay.
I'm not sure, with all due respects to my chairman, I'm not sure if I agree. I think at some point a value has to be reached, or they have to default to the existing assessment.
Well, that might be the answer there.
And if I can ask our distinguished guest here, what
doesn't mean it goes without valuation. It's got to. True, your point. It's got to have it's got to have a valuation for tax reasons.
Yeah.
It can't just be
let me ask it. What I'm suggesting is that if neither side carries the burden, then and the court may be authorized to simply apply the existing assessment.
That may be an answer.
Is that?
Well, that may be an answer.
But that may be the one that's being appealed from.
I know, but the point is,
previous assessment not appealed.
Just be recognized for comment.
Yeah, I'm sorry.
Talking either to the witness or the chair.
Mr. Majority Whip.
No, I didn't.
I'm sorry.
Please, I'll recognize you when you're ready.
I'm sorry.
Just keep it in orderly fashion. Are you through?
Yeah, my question is through.
All right.
Thank you, Mr. Chairman.
Who is next on this issue? Mr. Welch.
I don't think that there's any need to default to anything other than requiring the parties to then redo the case. I mean, there is, you can't resort back to the assessed value because that's why it's being appealed. You can't also have a situation where you default to the $10 value because of the property owner, because that may not be reasonable. But simply having it retried is the unfortunate reality that I see happening. So that means that the government needs to work hard to prove its case, do its job, and not waste taxpayers' time in doing it. And likewise, the property owner needs to put up the proper defense. Otherwise, it just needs to be reheard.
All right. Mr. Land.
I was just going to answer the majority whip's issue. The law since 99, I think, puts the burden on the tax assessors to carry the burden on value as to the fair market value. Now, what the current language is, by simply undeleting is to stop the $10,010 type argument. Yes. You have an incompetent assessors that come in and they don't have anybody other than the computer tells me this is the number. Yes, sir. And the judge says you didn't carry your burden. So he looks at the taxpayer, what's your evidence? Then you got an issue of credibility. Is the evidence that the witness, appraiser, or taxpayer gives credible? The judge has got to make a decision on that credibility. And the issue that's been raised is, what if the judge doesn't like either one? I think it's going to be like any other case. The judge is going to have to, under this code section, find fair market value, either on their own experience, some other expert, the taxpayer, or the tax assessor. I think at some point, fair market value has to be determined.
All right. The chair believes that what we have here is an issue that is not one for the court to find otherwise than what it may have before it as evidence. That evidence either being the tax assessor having met its burden, failing to do so, it can then as an option accept the taxpayer's valuation, and failing to accept that as being fair and reasonable value, the chair is of the opinion that it has to then go back and leave in place what is the current assessed value for the process to start again by the tax assessors going through a reevaluation, reassessment of the property, and bring it forward again. I don't think the court is sitting there saying, well, I'm going to have to leave this open, let y'all go do something different. I think the need of having finality to the court action, there has to be something done as a conclusion to that action.
Mr. Chairman, question to you.
Yes, sir.
Would it be satisfactory if the court determines that neither party has carried the burden of proof, for the court to have the authority to appoint its own appraiser to be with the cost of which to be assessed as
that's
between
not
the
the
parties?
duty of the court. I don't think that's the duty of the court under this circumstance.
I'm not requiring them. I'm
I know, but I'm saying to bring finality to it. I don't think it's frankly ever come up this way, but it's I accept if you, the tax assessor, have not met your burden, I cannot accept that and let that go to a finder of fact. You, property owner, I think yours is also very unreasonable because it has not been proven as being true fair market value. I'm going to enter an order leaving the current assessment in place, and you can start the process over again. That to me seems to be the only way to come to the court having a conclusion to it. But otherwise, you leave the action open. There's no way of telling the court, or the court really having guidelines about what they should do or not do with the single issue before it. We got more on this one point of these different issues.
Something.
Yes, sir.
Keeping in mind that this is an appeal from an assessment decision by the Board of Tax Assessors, and they have set a value, the taxpayer has disagreed, and they are now appealing that assessment to the court. And if the court finds that there has been no meeting of the burden of proof, this actually goes a little bit beyond just saying, I find you hadn't met the burden of proof and I'm throwing you back. It's saying that the court at least has the option if it finds the taxpayer has been reasonable in accepting the taxpayer. So it does go beyond just throwing it back out and telling them to go back to work and go back to talking again. So it does give that much, but still it is a denial of an appeal or the refusal of granting the appeal, and so I think it's appropriate that they go back to the drawing board.
What we're saying.
Yeah.
Correct.
In other words, I was saying I agree with you, Mr. Chairman.
Well, could you say it that way? Over here, Mr. Welch, I'm trying to get moved past this point.
Can we add, you had amended it with the language of authorizing the finding.
Let me read what I've done wording-wise, and we'll see what you got some wording listed what I'll have in just a second.
Yes, sir.
You have a comment, Mr. Weldon, or Mr. Crawford, excuse me. All right, I've tried to reword something. I'm going to read the sentence to you as I put it. Upon a failure of the Board of Tax Assessors to meet such burden of proof, comma, the court may, comma, upon motion or sua sponte, comma, find that the value asserted by the taxpayer is reasonable as the fair market value of the property, comma, or continue the current value and assessment, period. Yes, sir.
The only problem with that is that under current law, I believe, I have the right to appeal the current assessment if I get a notice that, say it's $100,000. Last year it was $100,000 the year before, and I get the notice of the current assessment as $100,000, but if I feel like the property has declined, I can appeal from that. And so your language says basically that if I appeal and they can't meet their burden of proof, that it then goes back to what I have appealed from. So I think you're better off just not even putting that.
I'm saying by appeal, I'm sorry, by current value, I'm speaking the one prior to the reevaluation, because what we're challenging right now is the reevaluation. We got several more comments here. Let's go to Mr. Welch. What's your wording?
I think that even if the reevaluation, when we've seen this happening where the reevaluations have been declining recently, and some people would say that that the assessed value by the tax assessor has not declined enough. So if you did it that way, you would actually revert back to the previous year, which would be higher than where the assessment had gone. So the language I was asking to put for you to consider was where the period is on line 1005. Insert, or in the alternative, the court may declare a mistrial, and just in the proceedings altogether.
And what is, as we questioned earlier, what will be the value for tax purposes? You can't leave without some value for tax purposes.
I think that at that point the parties have to go back, and the assessor's duty is to reassess the property.
That's what we're saying.
Reassess the property, and then again the taxpayer would have the ability to go and appeal that assessment if he disagreed with that.
All right, sir. Ms. Stevens.
In response to Andy's question, is it not the mistrial, is the language that you're remanding the case back, is not really the mistrial, you're remanding it back for yes.
Well, if you declare a mistrial, you just leave all the parties in the same status they're in, correct?
Well,
if you have a mistrial, the parties are left at that moment in the same pleadings before the court to be retried. Right?
Would it not be, I think Mr. Stevenson said.
Question.
Yes, sir.
If you declare a mistrial, then you left the parties before the court to be retried.
You have.
So that may be the answer.
And I think what Representative Stevens is saying, that the other way to handle it would be just to simply remand it back for a reassessment.
I'm looking at how much time goes by, but you still have the appeal in process. I would suggest probably having either the court, they've rejected the tax assessor, they've now not been willing to accept the taxpayer. The appropriate step would be declare a mistrial and let there be a retrial of the case with new submission of evidence. Correct? You say no, but you then still have the same value pending, and you still have the appeal still pending, and the court is saying, I'm declared a mistrial, I don't accept the evidence.
Yes, sir. And I think I think if we require the court to remand it back to the assessor to reassess the property, they may come back with the exact same assessment.
That's not necessary is what I'm trying to say, Mr. Welch, because by declaring a mistrial, you're going to start the whole process over. They can come in with a new appraiser or a better educated appraiser, whatever they need to do to establish their burden before the court.
I do see what you're saying. That would freeze it exactly where it is.
Yes.
And then they just retry it on the basis of the same assessment.
All new again. Okay. Everybody, any other thoughts on that? So moved.
The painter will get it.
I'm just writing something here for that purpose. What else we have, Mr. Land?
That's all,
You
Mr.
brought the
Chairman.
good ones up at the end, didn't you?
That's all.
How about you, Senator Rogers? You have any amendments?
The amendments that I've seen are all good. And I support
We've got in your file, let me just call everyone's attention, please, while you can continue this discussion. We've got, I'm going to try and read these to you. You got one called AM 292022, which deals with the fact that if you have a transfer of a tax execution and there be an appeal, you have an appeal filed, there cannot be a transfer of that tax execution to a third party. The tax commissioner's office has to continue holding that execution until there is conclusion of the appeal. And I think you got a comment, Mr. Lindsay?
No, just at the appropriate time I was going to make them.
Oh, okay, excuse me. I'm just going through the other amendments. We got also two sheets. I've got one of them styled LC 295268 ERS. These amendments, and I'll let, since I prepared these, let someone else perhaps present them. And then we have amendment styled Amendment 234, amending line 79 to change a word there on the by first class mail. All right, we'll have those. What I want to do now is, do we have anyone else who would like to address the committee? We do. I think Mr. Mueller, you want to address? If you move, Mr. Land, we have another party who wants to speak to the committee.
Real quick, Mr. Chairman, members of the committee, Clint Mueller with the County Commissioners Association. We appreciate the openness and the way and manner that Senator Rogers and both Chairman Willard have worked on this legislation with a coalition of interested parties, and we do support the legislation. I just have one quick recommended amendment, and it's something that you and I talked about this morning, but I didn't see it on your list of amendments. If you all will look at, it's in two places in the bill. If you'll look at page 20, starting on line, it's actually on line 6, well, it starts on line 683. This is the temporary payment that's made while the appeal is pending. And there's been a change to go with last year's. This may be hard to believe, but the majority of our counties in the state of Georgia do not issue building permits. And this basically has a requirement in here that they have to issue a building permit and structural improvements. Maybe the easiest way is just to change the and to an or, so it could be either one.
I think we ought to leave it like that because go ahead and do the other language we talked about. I think what we did do answers the question.
Okay, well, there's that place in the bill, and then there's also the same language that's on line 950.
No, we had some language we added. You and I discussed the language to be put in there was improvements added without a permit,
Right. Is that part of your amendment?
No. Is it on here?
Yes, sir.
It is. Okay.
Okay.
Thank you.
Okay.
That's in there. Yeah.
Okay. That's it. I just
All
wanted
right.
to make sure we got that changed. Thank
Two
you, Mr. Chairman.
times. All right. Further comments, Mr. Morris. Please come forward, identify yourself as your comments. Why don't you get over here of the chair where we get you. Come right to the other side.
I'm not an attorney. It'll be quick, sir. No offense to y'all that are. Okay. Yeah, I'm doing this quick. I've timed it. It's going to be 2 minutes unless y'all interrupt me or want to ask questions, okay? Now, I'm a candidate for Fulton County Tax Commissioner. I want to serve the people. I'm not like our current tax commissioner, okay? 4 years ago, I received assessments at over 800% more than what I paid for my rental properties, okay? Had to go all the way to court for 3 years. Not only one, the judge ordered all my legal bills paid for. You might want to congratulate me. But guess what? Tax liens were sold on all of them. They can't be corrected. So now I have 22% per year on an assessment that was 800% more than what I paid for it. You're going to say this type of property tax system is fair? Let me tell you something. You ought to be in there in the trenches with me and the other taxpayers when we go to court. Look at these things here. This lady is assessed at $112,000 when other people in her neighborhood are assessed at $17,000. Look at this the AJC did. This house was assessed at $193,000, but it sold for $750,000. I mean, the county's even missing out on money. This is ridiculous. Listen to these personal experiences, and I'm about to get through here. My family down in Muskogee County is being threatened with arbitration being held unless they will settle. That's how these counties operate, many of them. By the way, I'm not talking about Clint Mueller. I want to take back all the words you heard me call him. He's a decent and an honorable man, and I've found out that, okay? He really.
You want that in a motion, or?
I'd like.
All right.
I would. Okay. Well, like I said, I'm going to be quick here unless you interrupt me here. Okay.
Back in order.
Then I got Forsyth County threatening us to be arrested if we leave our appeal before they announce the decision. Clearly against the open records law. I got DeKalb County openly admitting they used illegal data to assess properties. Got Clayton County saying we're not going to use bank sales, even though that's clearly in the law. What can we do? Sometimes it doesn't matter what you pass up here. They don't care. What are you going to do to them? Yes, you're right, sir. Excuse me, the anger got there, you know. I'm just telling you why you need to make these changes, okay? Bottom line is here, I just want to remind each of you, and this is closing here, who you fight for. You fight for the people. I want you to join these champions like Senator Rogers, Ed Lindsay, Chairman Wendell Willard, who have only met here in the past 2 sessions, but I've learned he epitomizes the meaning of the words representative of the people. Thus, I ask you to join with the chairman, vote for this bill, and truly represent the people who elected you. I do have Ms. Johnson's family that would like to say a couple of words. This lady, 87 years old, passed last year, and she did not have anything to leave to her family because the county took it. Mr. Johnson?
I think I'll recognize people if you don't mind. Please come forward and give us your name, and please make it a brief statement. We're running late for other
my name
committees.
is Clarence Johnson, and I'm a resident of Fulton County. My family has been there for 70 years. And I just want to say that my family purchased property in Fulton County in 1953, and it still remains there. And my mother had a small business, raised 11 kids. And to make a long story short, for the last 10 years, her property taxes were like 100% higher than they should have been. It worried my mother to death. She passed last year, and we would like to see whatever could be done for other people and elderly people for the county. Thank you.
What we're trying to do, very much so. Thank you.
Thank you.
With that, we're going to close off public permit. in public comments, I want to ask, though, one thing. I want to bring to your attention, I've got a change that I brought into the bill, and that change begins in Section 12. This carries over from the provision that I started several years ago, back in 2006, to limit the ability of the tax commissioners of the counties to have private personal income contracts with municipalities for services they perform in their official capacity, which is the billing and collection of taxes for municipalities. We had a dual system where it was a county of less than 50,000 parcels or a county more than 50,000. We've taken out that part. That's part of what you see has been struck through in the beginning of it. I've been working with Richard Royal, who is the representative of the tax authorities, both commissioners and assessors. Richard Royal, if you will, I don't have the bill where I made my changes. Do you have the language where we put the specific parts in there that the tax commissioners wanted? Yes. Would you come up here and so just read that to us so I can get that inserted as we get ready to go through all the amendments? I lost my copy of the bill somewhere with all the shuffling I've done today with papers.
Thank you, Mr. Chairman. On line 1167, we wanted to add "and the tax commissioners" in conjunction with the county governing authority and the municipality.
So we'll say, all right.
They would be at the table there.
I'm going to say the county governing authority, comma, a municipality, and the tax commissioner?
Yes, sir.
All right.
On line 1185.
Yes, sir.
We discussed after.
Oh, here they are in here? I beg your pardon. We do have it in the amendment form. I beg your pardon. I didn't realize we had it that way. Great.
Thank you, Mr. Chairman.
Thank you. We got them in the amendment form. Sorry. All right. No further comments. The chair closes off further public comments. The bill is now in the breast committee. The chair will entertain a motion. It's been moved to pass. Do we have a second? It's been seconded. We have amendments. I know on the table we will go through. I'm going to try and do this in as orderly manner by pages that we can. We have no amendments to page 1, to my knowledge. Page 85. All right. And the others start on lines page 64. Nothing on page 2, nothing on page 3, on page 4. Excuse me, page.
There is an amendment on page 3, which is this amendment, small sheet that you have, amending line 79.
79, you're right, sorry. All right, on line 79, we have changing the word, let's see, after the word by, excuse me. Yeah, by first class mail and certified mail. So on line 79, after by, we'll put in first class mail and certified mail or statutory overnight delivery. Is there any discussion on that motion? Any disagreement? The chair will go ahead and accept that motion as an amendment. Yes, sir, go ahead.
Is it and or?
Well, no, I'm suggesting this is being done by following the transfer and execution. So you got a third party holding that execution. The intent is to have them at least give a first class and certified. Point being, as you do in law office, a lot of times you'll send something out certified mail, but you also send a copy first class.
Okay.
If you never get back your first class, the law assumes it's been delivered. Your certified may come back saying they refused and never came to pick it up, so you don't know. Okay. Yes, sir, Mr. Hatfield.
I was just curious as to where does the statutory overnight delivery fit into that?
That's option to the certified mail.
Okay.
I think we might want to put a copy after certified mail. So it'd be by first class mail and certified mail, comma, or statutory overnight delivery.
Mr. Chairman?
Yes, ma'am.
I think that the intent of this amendment was to have it be one of the three ways.
I think you may be right, but I'm saying I'm suggesting that what I would like to have done is you sent out first class mail and certified mail or overnight delivery.
Yeah, I like that. No comment.
Pardon me? Go ahead, Mr. Hatfield.
I was just going to suggest, if that's the chair's intent, then wouldn't it be a good idea to put in there like a 1 and say by certified mail and 2, by 1 first class mail and 2 by certified or statutory overnight delivery?
I'll leave that up to Mr. Allen. How do you want to see that done, Mr. Allen, to accomplish this?
I think if you add in first class mail, I think if you want to make it clear, it'd be good to enumerate them.
All right, so by 1 first class mail and certified mail or 2?
Yes, sir.
All right, we will take that as a friendly amendment. So on line 79, be sent by 1 first class mail and certified mail, comma, or overnight delivery. All right?
Okay, Mr. Chairman, just
Yes.
to clarify, what you're in doing it that way, that would join the first class and the certified, but the statutory overnight would stand on its own.
Correct.
Okay.
That's correct. Anything else on page 3?
Yes, Mr. Chairman.
Yes, ma'am.
Also on line 85,
Same thing.
we'd like to put back in the first class mail.
Right. So we're going to do about, again, 1 first class mail and certified mail, or 2 statutory delivery. All right. Anything else on page 3? If not, we'll go over to page 4. And we have until the execution is paid in full or satisfied, the same thing. By notice of regular mail, it doesn't require the overnight delivery, so this would be by regular mail and certified mail, as was suggested by Mr. Land, I believe. Line 115, is that amendment acceptable to everyone?
So moved, Mr. Chairman.
We're just going to find it. We're going through a reading. If there's an objection, then we'll just, for this ability of time. Yes, sir.
Was there a change on line 110?
110, there was a change. Regular mail, after regular mail inserting and certified mail to the delinquent taxpayer.
Is statutory overnight delivery added there as well?
We didn't want to do overnight delivery there, just regular mail and certified mail.
Okay. Thank you, Mr. Chairman.
Mr. Chairman?
Yes, ma'am. What's that? I'm sorry, I couldn't hear you. Somebody's phone went off. Let's silence phones in here, please. Go ahead.
Mr. Chairman, on line 110, just to be consistent, instead of saying regular mail, shouldn't we say first class mail?
That'd be fine. Good point. First class mail and certified mail. Because then on line 115, is that acceptable? As any objection to that amendment? The chair accepts that amendment. On line 115, we have inserted at the end of it by first class mail and certified mail after that. Any objection to that amendment? Not, the chair accepts it. Any further amendments from page 4? None over page 5. Do we have any amendments on page 5? I see none on the sheet. Page 6, any amendments? I see none. I got lights blinking. If you're gonna have an amendment, that's the best thing to do is just call my attention to it. All right.
Mr. Chairman, I believe on page 4, line 126 is where we wanted to insert I for the amendment 292022.
Exactly. Thank you, sir. We have the amendment AM 292022, which inserts a new paragraph I at the end after line 126. Has everybody had a chance to read that over? Is that Anyone have objection to the acceptance of the amendment 2022? If not, it is accepted. Page 5, any other amendments? I see none. Page 6, we have an amendment on page 6. Looking at lines 202, 203, it says such advice and assistance shall be in compliance with the laws of this state and the rules and regulations of the commissioner. And Ms. Land, you had something I never wrote down what you had here, or was that yours?
Council has it.
Okay.
You want me to read it out?
Please read it.
The way the proposal is, on line 203.
Pull your mic down, please, so we get. I got to turn you on. Okay.
On line 203, after the period, insert a new, after the commissioner period, insert a new sentence. Such contracts shall only be entered into with persons who complete satisfactorily such training courses as directed by the commissioner, period.
All right. Everyone understand the addition? You got a question to that, Mr. Crawford?
Yes, I do, Mr. Chairman. I just want to make sure I understand. This language, as I understand it, is talking about the actual entry into the contract. And would that not on many occasions be with like a corporate entity that itself would not have any training, but what we're really trying to get at is any individuals performing the services pursuant to a contract should have this training.
Read your sentence again, would you, Mr. Allen?
Such contracts shall only be entered into with persons who complete satisfactorily such training courses as directed by the commission.
Why don't we say individuals performing under the contract? Because you could have a contract with an entity other than an individual. So individuals performing services under the contract shall be required.
May I read that back?
Please.
Such contracts shall only be entered into with.
No. That's the part I was trying to start this sentence with being individuals performing services under this contract shall be.
Individuals performing services under such contract shall complete satisfactory such training courses as directed by the commission.
Correct. Does that take care of what you're talking about, Ms. Crawford?
I think that addressed it, Mr. Chairman. I'm just, with that language, performing duties pursuant to such contract, but the existing language in here doesn't really refer to a contract.
The language of the prior prior sentences do. The whole section deals with the contract.
Okay. I'm just a recovering lawyer, Mr. Chairman.
Okay. All right. Anything else on page? Is that amendment acceptable by the committee? Anybody have objection? It is accepted. Page 7. I don't see of any amendments. Page 8. I see no amendments. Page 9. I see no amendments. Page 10. I see no amendments. Page 11. I see no amendments. Page 12, I see no amendments. Page 13, I see no amendments. Page 14, I see no amendments. Page 15, I see no amendments. Page 16, I see no amendments. Page 17, I see no amendments. Page 18, I see no amendments. Page 19, I believe it's 684. That's on the next page. So page 19, I see no amendments. Page 20, I believe on lines 24, 684, excuse me. This is where we get into the building permit issue. Unless the property in issue issued a building permit and after the word occurred, okay, improvements have occurred, comma, or structural permits, it's supposed to be structural improvements, have occurred without a building permit. That's what it's supposed to read. That's why I was having trouble. Structural improvements have been made. Let me get that correct for you so I can read it right. Now, I read that back for everyone so you understand what the language is. It'll read at the end of line 284, I think structural improvements have occurred, comma, or structural improvements have been made without a building permit, comma, in which case it shall specify 85% of the current year's valuation, etc. Does everyone understand that? All right. Is that acceptable? Accepted it? All right. Page 21. I see no changes. Page 22. I believe we have a change at 769, which would be the same. No, it's different. I'm sorry. Page 69, after parties, is to be inserted a sentence, the hearing shall take place in the county where the property is located or such other place as mutually agreed to by the parties and the hearing officer. Yes, sir. It's on the sheet too. The hearing shall take place in the county where the property is located, comma, or such other place as mutually agreed to by the parties and the hearing officer. That is suggested as amendment, sir.
I had one other question.
Yes,
I'm
sir.
sorry. Based on the gentleman's presentation earlier, if I understood correctly, back on line 727, he was proposing to move the language currently found on lines 800 through 802 and move that to end of line 727. Is that correct?
At line 727.
Yes, sir.
And what we're moving now?
Lines 800 through 802 in their entirety. Move them in between lines 727 and 728.
Yeah, I just ain't got over there yet. Right.
I'm sorry.
No problem, that's fine. Yeah, here it is, line 800, which is paragraph 10. That would be removed and placed back over in at line 727. The end of that would now become a new 10 for that series, correct? And then we'll renumber at 803 accordingly. That's offered as amendment. Any objection? It's accepted. Next we're going to have is the 769 is where I was. We'll go to line 769 to hear evidence and testimony from both parties. We inserted that sentence. The hearing shall take place in the county where the property is located or such other place as mutually agreed to by the parties and the hearing officer. Is that agreed and accepted as an amendment? No objection. It's accepted. No other amendments on page 22. On page 23, we have amendments. We've already taken the one about the moving the paragraph 10. We go down to line 806. Yes, sir?
I noticed here on the sheet an amendment, unless I'm misreading, on line 773.
You're right. Excuse me. You're right. I'm sorry, I missed that one. Go back to page 22, line 773. We did change, this is changing the time by which the parties are to exchange evidence, written documents before the hearing. We changed that from 24 hours to 7 days. Is that accepted, or is there any objection to that amendment? We felt you had to give some reasonable time rather than 24 hours. Thank you, Mr. Carver. If no objection, that is accepted as an amendment. We're back over to the reading on lines 806, sorry. It says determined by the county governing authority, and then insert or as may be agreed upon by the parties, period. Insert in that phrase. That's offered as amendment. Is there any disagreement? If not, it is accepted. The next one the chair has is on line 810 is striking out the sentence beginning if the clerk of the Superior Court, comma, after diligent search cannot, etc. Striking that sentence, striking all the way down through line 815. That's offered as an amendment. Is there any objection? If not, it is accepted. Any other amendments on page 23? There being none, we'll go to page 24. First amendment the chair shows is on line 842. After 45 days, striking out of the filing of the notice, and leave it just shall within 45 days. That doesn't read right. From the transmittal. Mr. Land, I'm trying to read what you want to have here. Somebody.
I've got it, I think, Mr. Chairman.
You've got it? Thank you. What is it, Mr. Allen?
On line 842, strike filing of the, so it shall within 45 days of the date of transmittal.
Of the date, that's it. That's what we did. Of the date of transmittal, right, okay. So it reads now, shall within 45 days of the date of transmittal of the acknowledgement of receipt of the appeal, etc. That's offered as an amendment. Is there any objection? If not, the chair accepts it. The next one the chair shows on line 851, appointment of the arbitrator within 45 days of, then striking out filing of the notice of appeal and insert in lieu thereof the acknowledgement of the receipt of the appeal. Therefore, read, within such 45 days, elects to have the appeal immediately forwarded to the Court of Equalization prior to the appointment of the arbitrator, and within 45 days of the acknowledgement of the receipt of the appeal, the taxpayer shall provide a copy of the certified appraiser, etc. That's offered as a amendment. Any objection? If not, the chair accepts it. Page 25. Do we have any? Nothing is proposed on page 25. On page 26, top of the page, we have, begin line 898 through 899, Superior Court of the circuit in which the property is located when 30 days after then we strike the next line and we insert the following a petition by either party, period. That is offered as amendment. Is there any objection? If not, it is accepted. Anything else on page 26? If none, we'll go to page 27. Do we have any amendments on 27? Yes, sir. Recognize you.
Thank you, Mr. Chairman. I'm sorry, I misunderstood. In your amendment on page 26, you're striking line 899.
In its entirety, yes, sir.
And then inserting filing
of a petition by either party.
Okay, I misheard you.
That's dealing with the time frame in which the court is to appoint the person to serve as arbitrator.
Yes, thank you.
Anything else on page 27? Any amendments on 27, rather? Sorry?
Building permit.
It is there, too. That's right. Thank you. 956, we have the same thing. Unless the property in issue has been issued a building permit and structural improvements have incurred, comma, or structural improvements have been made without a building permit. That is the language to be inserted. That's based upon what Mr. Mueller said. Sometimes a lot of these counties don't have the building permit process. That is offered as amendment. Is there any objection? Yes, sir.
I have no.
Put your mic down.
I don't have an objection to the amendment, but isn't that different language than the way we put it in the first place we had that language?
I was reading from my copy. And I made changes on the copy that I have that was also inserted earlier. Now, if you're reading from the sheet, I did change the language because I felt it did not read correctly, correct English.
Okay.
You all right?
All right. Thank you.
Is that what you're looking to? All right. Anything else on 27 as far as amendments? Anything on 28? We have an amendment. This is where we got the long discussion. And what we have at the bottom is beginning on line 103. I'll read the sentence beginning on 102 in its entirety and be sure everybody is in agreement. This is proposed as amendment. Upon a failure of the Board of Tax Assessors to meet such burden of proof, comma, the court may, comma, upon motion or sua sponte, find that the value asserted by the taxpayer is reasonable as the fair market value of the property, comma, or declare a mistrial, period. Does everyone have that? Alan, Mr. Allen, do you have it?
Yes, sir.
I'll read it one more time. Upon failure of the Board of Tax Assessors to meet such burden of proof, the court may, upon motion or sua sponte, find the value of the taxpayer by the taxpayer is reasonable as the fair market value of the property, comma, or declare a mistrial. Period. That's. Does everybody understand on the committee the amendment? Yes. Is there any discussion? We have discussion.
Mr. Chairman, I was just going to clarify something. On after reasonable, the word that you have there, I think, is as the fair value. I'm just wondering, should it be reasonable and the fair market value of the property?
I'm fine with that. I'll accept that. Is reasonable and the fair market value of the property, comma, or declare a mistrial.
Yes, sir.
All right, period. That's all for the amendment. Any further discussion on the amendment? Then the chair accepts that amendment. Anything on page 29? Nothing on 29. Page 30. I think we're down to almost nothing on 30, nothing on page 31. Do we have anything? Nothing on 31. On 32. Nothing offered on 32. On 33. We have amendments proposed on 33. And I'm going to start with the first one I'm looking at is on line 1167. And I'll read it. The governing authority, comma, a municipality, and the tax commissioner. So we're putting a comma, striking out the and after authority, a municipality, and then inserting and the tax commissioner shall specify an amount to be paid by the municipality. That's offered as an amendment. No objection. The chair accepts that amendment. The next amendment we have line 1185. And that is after the, I'll read it on your sheet, by inserting after county on 1185 the following: with the consent of the tax commissioner, comma, to prepare the tax digest for such municipality. $11.85. Not through. That's offered as amendment. Any objection to it? It's accepted. Line 1192. We have by replacing for with directly with a municipality. So it says prohibited from contracting, and then strike for, then say directly with a municipality for an accepting. I'm sorry, an accepting. as offered as an amendment. Is there any objection? The chair accepts it. Anything else on page 34? Anything on page 35 or page 36? Do we have any other amendments? If there be no further amendments, the chair will call the main question, which is due pass Senate Bill 234 as amended as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you.
Go get some House bills out of rules.
I'm going with you.
That's all about Mr. Chairman.
Yep.